The 261st District Court is now in session. The Honorable Laura Livingston presiding.
Thank you very much, Ms. Lawson. Good morning, everyone. I'm ready now on cause number GN 19008278, FLOSPORTS versus Rokfin Inc. And in just a few minutes, I'm going to ask for your announcements. But before I do so, I need to make just a few announcements of my own. First, we are live streaming on YouTube. If there is a reason why that live stream is not appropriate for this particular case, I'll entertain argument on why we should stop the live stream. Otherwise, we will be live streaming on YouTube in accordance with the Supreme Court's emergency orders and in accordance with the Travis County emergency orders during this pandemic. In addition to that, the court reporter is going to take down the only official record, and for that reason, no one may audio or video record these proceedings. Once the hearing is over and the live stream ends and is no longer necessary, I will make it private, and at some point when I'm satisfied I no longer need it, I will delete it. If you need a transcript, you may make arrangements for such with the court reporter. We have a visiting court reporter with us this morning. His name is Stephen Stogel, and so you may contact him at the Travis County Courthouse where he is employed, but today working with our court. I think those are all of the sort of, I guess I should remind everybody that you may under no circumstances privately chat with the judge, and you may not privately chat with any witness while the witness is testifying. I believe that's all the preliminaries I need to tell you about. And now, if you would please, for the plaintiff, make your announcements of counsel.
Hi, Judge. This is Karen Burgess. I'm here for FLOSPORTS with Katie Dolan Galaviz and my paralegal Eric Boucheron. Also from FLOSPORTS, we have Paul Hurdlow and Wesley Sullivan, who will probably need to be excluded once I start my opening because it has some documents the opposition has designated.
All right. Thank you. For the defense?
For FLOSPORTS, Your Honor, Martha Dickey, Scott Brudico, and Kelly Klingseisen.
I'm sorry, I didn't hear the last name.
Kelly Klingseisen.
You spell that for us, please?
It's Klingseisen.
The court reporter, and I thank you. All right.
And Your Honor, this is Carlos Soltero for the individual defendant, Mr. Willie Saylor, who is here with us as well. And Judge, one thing to clarify, I've mentioned this before Your Honor came on board. Miss Vanessa Suarez, who's a new associate with our office, is here as well. She's not on camera and she won't be speaking, but she's observing the hearing.
All right, thank you. If it's not necessary for you to speak, please mute your microphone. If it's not necessary for us to see your video, you have the option of stopping your video, in which case we'll hide all non-video participants. You have that option on your screen as well, and that will make more space for those that are actively participating in the proceedings. It's my understanding that we are set this morning on a motion for contempt and a motion for sanctions, both brought by the plaintiff. Is that correct?
Yes, Your Honor.
And is there anything set on the docket today?
The only thing set for on the docket is the emergency motion.
Okay, all right.
One little housekeeping. My name is Butch Hayes, and Jeff Weisbart and I represent non-party Martin Floreani, who is trying to re-sign in because of his video, some video issues.
Spell the last name of your client, please.
Floreani, F-L-O-R-E-A-N-I.
All right, Mr. Hayes, you must have some other device in your presence, and if you would mute the microphone on one of them, I bet we'll hear less of that noise you're making over there. So I'm guessing that feedback is coming from one or more of your devices, and so if you'll just mute the microphone on one of them, that should solve our problem. We'll test
I'm going to put that at Mr. Weisbart's feet, so we think we're taking care of that.
All right, very good, thank you. Okay.
And Your Honor, we have some procedural issues also before we get started when you're ready.
I'm ready.
Okay, so FLOSPORTS has filed 1,500 pages of stuff here. We have 3 different parties that are accused of violating an injunction. Rokfin, Mr. Saylor, and Mr. Floreani, represented by 3 different counsel. We would respectfully request the court to allocate time between those. We're of course not going to be able to hit every single point in her 1,500 pages, but we would request that the defendants whose conduct is being discussed have an hour and a half, and the plaintiff have an hour at this hearing. I know that everyone's going to be on a budget for time, but we have 3 witnesses to put on, and I think that's important. Second, Your Honor, FLOSPORTS filed their exhibit list and their witness list this morning. They posted it last night at midnight. That violates the rules of this hearing, and I would request that because of the late notice and our inability to review in detail their exhibits or to prepare our witnesses, which they named, that those 2 things be struck.
Judge, first of all, the 1,500 pages are examples. There's only about 25 pages of briefing in total. That's both the original motion and the emergency motion. And I believe only the emergency motion is set, but the 1,500 pages are examples of violations of your order. We are calling the 2 party witnesses, not Mr. Weisbart, but we're planning to call Mr. Saylor and Mr. Floreani in our case. And so it will be blended, and I would suggest that cutting that in half that was actually top of my list too, Ms. Dickey, was was trying to come up with time limits to start. But the standing order actually says that these will be filed in advance of the hearing. It does not say days in advance of the hearing. It does not say how many hours in advance of the hearing. It merely says in advance of the hearing. If not all, the vast majority of all of that has been on file since June 8th, and then since the beginning of August when we filed this this emergency motion as well. So with the additional items, examples of violations.
Your Honor, there's 17 exhibits that we've been able to identify that were not attached to anything else. FLOSPORTS was capable of filing another 460 pages of documents at 6 o'clock yesterday. The fact that they waited until a half an hour, as she says, on something that she's had pending for a long time to identify witnesses and to identify exhibits is just more ambush. And
But Joy only identified their
Excuse
witnesses.
me. Oh, Ms. Burgess, wait until she finishes, please.
I will.
It's
I know it's
very
harder.
difficult. It's very difficult in court when we're all together in the same room when people are talking at the same time. It's especially difficult in this remote environment. Ms. Dickey, you may proceed.
I'm finished, Your Honor. I appreciate it.
Okay, so here's my question. How much time do you really need for this hearing?
Well, we are planning to call, they've named witnesses. We're planning to
No,
call.
no, I think about it.
Okay.
Just give me
all
a
right.
time.
Okay.
Because
I would agree with
let me
Ms.
stop.
Dickey.
Let me stop you there and explain the reason I'm asking the question. The docket from the court administrator's office to me says that you announced for 3 hours. But given the concerns about time, given the concerns about the volume of documents, given the concerns about the number of lawyers who represent the number of different parties that are subject to the motion, I'm in doubt about whether or not you can actually accomplish all of this in 3 hours. And I'm wondering if we shouldn't reset it for a Monday next week when you've got a whole day, because I don't see it happening in 3. You have to be finished by noon today because I have another setting this afternoon on a case that was set on the long docket that needed more time. So I'm just wondering if 3 hours is enough time given all of the concerns that have been raised. And so that's the reason for my question. I couldn't actually do it Monday. I could do it Tuesday, but I can't do it Monday.
Your Honor, may I be heard?
That's my question.
Your Honor, may I be heard on that point?
Sure.
Your Honor, in our response papers, which were done over the weekend in order to respond by Monday, we indicated we thought a day was more appropriate time announcement. I still think that's really more appropriate. I also suggested in there that there's a number of other motions that we could take some time, confer on, and if not resolved, they could be handled fairly quickly within that day. And so I would respectfully suggest that that's more appropriate, and whether it's next Monday or Tuesday or the following week, that makes the most sense to me. We'll of course make use of whatever time the court allocates to us. But we'd like at least, like Ms. Dickey said, an hour and a half to 2 hours with our witnesses.
And
Obviously, that can't happen in 3 hours. So here's my question. It's pretty simple. Do we need, can you realistically do all of this in 3 hours? And if the answer to that is no, then the question is, are you available next Tuesday to do it for one day?
I think the answer is yes, but if we need to do it, that is fine. I would keep it to this motion and perhaps a status conference as opposed to trying to glom on all of the motions. The defendants continue to violate the order even this weekend. They posted things outside of the carve outs in your injunction about recruitment, which is not carved out at all. So every day that goes by, our client is harmed by the contempt, but we will do whatever the court thinks is best.
Your Honor, we could use a full day. And the only reason we announced for 3 hours is because we thought we were only offered a half day. And so we announced for as much as we could. I think given the limitations of Zoom and the fact that we have not had an opportunity to examine her exhibit list or prepare our witnesses, given the late filing of those things, that we would be well served to set it for a day next week. I'm checking my calendar. And I know I'm available. I don't know about other council and parties.
Well, next week is challenging because calendar is pretty full. So let's do this. Let's start this morning. I'll give you the 3 hours this morning. If you need more time than that, we'll figure out next week sometime, but everybody should be looking at their calendar now for availability on Tuesday of next week in the afternoon. I'm not available in the morning, as it turns out, but I am available in the afternoon. So if we don't finish today, we'll try to finish up next week. But I'll do my best to try to finish you this morning. The only thing I have said is the motion for contempt and motion for sanctions filed by the plaintiff. I don't have any other settings on my docket. So that's all I'm going to take up, and that's all I'm going to hear, at least today. And if there are other motions that need to be set and have been noticed, then we'll figure out a time to get those heard. And I'll try to accommodate you next Tuesday afternoon if necessary. And if you need more time than that, for other motions that need to be set, we'll figure out some time to do that as well. But we've got the morning. Let's take it and at least get started, and we'll see how we go. I'll keep track of how much time everybody has. I'm not going to decide today what that looks like because I don't know if we're coming back or not, and that might be pointless to worry about minutes if we're coming back to finish up on another day. But I'll keep track of who's doing what. In the meantime, let me hear opening statements on this one motion that's before the court this morning. Ms. Burgess?
Yes, Your Honor. And as a preliminary matter, some of my opening, which I have a PowerPoint for, involves documents that Rokfin has designated AEO, attorney's eyes only. And so strangely, I'm asking you to exclude my own clients from the Zoom room. Those would be the only people that would be need to be moved over. And that's Wesley Sullivan and Paul Hurdlow.
Well,
or I could ask them to.
You might want to remove attorney's eyes only documents from your PowerPoint because we're streaming live on YouTube.
Well,
so
maybe
if they're AEO and you don't want anybody to see them but attorneys, that's not going to be accomplished very easily if we're on YouTube. So
well,
you might want to skip those slides or figure out a way to send them to my office in camera with copies to other counsel and refer to them by Bates number or exhibit number or something else. But I don't know how you're going to accomplish it. I'm happy to put your witnesses someplace in a conference room or waiting room or breakout room as necessary but I don't
Are
know
we
that your
able
display
to,
of documents is going to be easily accomplished in this environment.
I think both sides have agreed that, that a preliminary sealing would be appropriate and that going off of the YouTube would make sense. But if not, I will talk through it without using any attorney's eyes only slides. And I would ask Mr. Bouchron to send counsel and the court the full packet.
Okay.
Okay, may I share screen?
Yes.
Okay, we'll see how this works. Most of the time this worked out for me, but let's get in there.
And Your Honor, this is Carlos Soltero. As a matter of procedure, sometimes there are things put in these PowerPoints that we believe will be objected to and not admitted. We anticipate. Prefer that we go ahead and object as soon as Ms. Burgess is speaking and brings it up, or would you want us to have her continue with her opening, regardless of whether it will ultimately be admitted or not?
Ms. Burgess's opening statement is not evidence, so I don't see the need to object. When it's your turn for your opening statement, you can make whatever comments you wish to make, also not evidence about whatever she said. But for now, I just want to hear everybody's opening statement.
Yes, Your Honor, understood.
Thank you, Judge. Judge, the defendants have never complied with your temporary injunction. That has really escalated over the last month as FLOSPORTS hosted only the second major wrestling tournament since COVID at great expense, brought people into the Omni to socially distance, tested, had special matches that would be as safe as possible. And in their competition in violation of your order, the defendants attack FLOSPORTS and then they link to Rokfin to move people over, to get people to flip.
Your Honor, may I interrupt for a minute? We're being presented with the issue that Mr. Soltero just raised, which is she has on screen a confidential document.
Well, let's not put any confidential documents up on the screen. So let's make sure we don't do that. All right.
All right, and so the since, like I said, since the beginning, they haven't complied, but recently, particularly in conjunction with FLOSPORTS wrestling tournament, they've used attacks to then try to flip people over to Rokfin. And they've even accused FLOSPORTS of supporting and condoning domestic abuse and violence as part of this, which I will show you. It's worked. There's been a significant number of people who have dropped their FLOSPORTS accounts and posted that they're going to Rokfin. That is a direct violation of the competition prohibition in your order. This very weekend, they posted recruitment stories, which is not at all in the carve-outs in your order. Since Saylor talks about wrestling, he doesn't wrestle. He rarely broadcasts. He is actually exactly the kind of content is king that is very important during COVID. We are asking that the court that the court do several things, and we sent you a notebook that kind of has our outline at the beginning, as we usually do, as well as 2 orders that are for both contempt and to extend and expand the temporary injunction. We're asking that you compel them to comply with your order, that you award fees for their persistent violations, that you expand the temporary injunction to remove First Amendment carve-outs that Judge Jenkins said were not concerns in his summary judgment ruling, and that you extend the temporary injunction until a trial date, which we are happy to proceed with as soon as possible in a bench trial on Zoom. I'll note that the non-compete itself expressly states that it will be extended by any time that Mr. Saylor is in violation of it. Now I'm going to, sorry about that. Okay, we're going to start with just background and go to the authority for this, the basis for the contempt, and then the basis for a request. You'll recall that Mr. Saylor is an on-air personality. He was at FLOSPORTS and now he's at Rokfin. Both are like Netflix. They host content behind a paywall. Subscribers pay FLOSPORTS for access to wrestling and all sorts of other content. And now they pay Rokfin to access Willie Saylor's content about wrestling. Over the years, FLOSPORTS invested hundreds of thousands of dollars in Mr. Saylor. This was the studio they created for him. They sent him all over the world, to Croatia a number of times, apparently. He started from 69 Twitter followers when he joined FLOSPORTS to over 22,000 when he left and took his audience to Rokfin. Rokfin recruited him for most of a year. When he got there, he removed rankings from FLOSPORTS and he reposted them on Rokfin. He accessed a Rokfin proprietary database, a FLOSPORTS proprietary database even after he went to Rokfin. That's Periscope. I know it's been a while, but you may recall that. And he tweeted out confidential FLOSPORTS salary information. Since then, he's tweeted about this court. He's tweeted very consistently in violation of the court's order, and he's almost daily violated on Rokfin as well. And Rokfin pays, I think this is particularly important, pays to advertise Saylor on Facebook, and he uses it, he does that using FLOSPORTS information. Even after the temporary injunction. We'd like to, after we get through this, we'd like to call Mr. Saylor to testify, Mr. Floreani to testify, and then I would testify about fees. And I'm going to try to get out of, I'm going to go in show so I can go to particular slides instead of running through without knowing what comes next. Okay, you'll recall that this is the only case I've ever had where the tortious interference is run by the person who signed the non-compete. Mr. Martin Floreani signed when he was, you'll recall that he and his brother co-founded FLOSPORTS. He signed Mr. Saylor's non-compete and then yet and still is tortiously interfering with it. He could not have more knowledge, Rokfin could not have more knowledge about what it is that Mr. Saylor agreed to. And he agreed to three different ways to not compete. Not to compete in as a competitor, and to not serve as an employee or a consultant or otherwise as a competitor, which is, he's doing all three. He also agreed not to solicit our customers, which he's doing every day when he attacks us and links to Rokfin. This is important because it is an express term. You know Texas's equitable tolling doctrine, where a temporary injunction or a non-compete can be tolled during the time of violation. This provision actually has an express provision saying that during the time that he's competing, it's going to be extended for that same amount of time. And this just breaks down the different provisions of the non-compete. He shall not compete with the company, participate in the management of a competitor, or have the same or similar duties. This is Periscope. This is the specific database that FLOSPORTS uses to determine what makes someone want to click, what makes someone want to subscribe, and what makes someone want to engage. And this is Mr. Saylor's usage of that, even after, you'll see that it spiked after he went to Rokfin. He was engaging with Mr. Floreani, Martin Floreani, about Rokfin to make his channel on Rokfin exactly what Flo was. When asked by a FLOSPORTS colleague why he went to compete, he asked, not immediately compete, you think I was going to become a school teacher? So honoring his contract was not high on his list, on his agenda. And Mr. Floreani texted out that when Legacy can't compete, then they resort to, I guess, enforcing their rights in court. He also compiled a team, despite his own non-solicit. Mr. Floreani compiled a team that he calls FLOSPORTS Plus. Most of these folks are from FLOSPORTS. You'll recall under your own question, or you may not, it's been a while, it's been since December 30th, but you actually cross-examined or you questioned Mr. Saylor during his temporary injunction testimony, and he did the exact same work at Rokfin as he did at FLOSPORTS. By this time, he had gone from being a W-2 employee for Rokfin over to being a consultant or a creator for Rokfin, but nonetheless, he was doing the same work. And he admitted that that was competition in a certain sense for sure. Again, this is you questioning the witness, and he agrees that he wants people to follow him at Rokfin, subscribe, they pay $10 a month, just like he did at FLOSPORTS. You found of course, it's a temporary injunction, so you found a likelihood of success on the merits and a probable right to recovery. And there are 3 provisions. Some of them have multiple parts, but 3 prohibitions in the temporary injunction. You should not compete against FLOSPORTS by providing products and services in the video sports industry, including by performing services as employee, consultant, or otherwise for Rokfin. I don't know why employee is underlined there. Now he's a consultant or otherwise, and he was at the time of the TI as well. They should not use or publish any proprietary information, which they are also doing. Also, their use of monikers and catchphrases are prohibited. And this is where specifically the monikers and catchphrases is where when his colleague asked Mr. Saylor, aren't you prohibited from using these monikers that we're going to use to advertise on Facebook? He said, I don't give a F about that. And that's a production document that this court has seen. That is the attitude that the defendants have about your court's order, this court's order. Oh, I'll add on that, that provision 6 also prohibits video, live streaming, and broadcast. So it really has 2 parts. Now there are carve-outs. You may recall this because it's kind of, we don't get a lot of, I don't get a lot of constitutional issues in my cases. But the defense, their main argument during all of this was the First Amendment. They raised First Amendment concerns. And the court wisely said, on a temporary injunction, I don't have time to analyze these, move for cross motions for summary judgment on that point, and then we'll know more. Well, so the carve-outs here are allowing, the first one's kind of repeated twice, but it's writing, producing, or publishing written editorial content about future sporting events, and then rankings, you'll see. Well, we did what the court said, both sides did. Immediately, we moved for summary judgment on the First Amendment and some other items. And Judge Jenkins agreed with us that the First Amendment is not implicated here. In fact, we brought in Doug Alexander and Anna Baker to argue this particular issue because it was a thorny legal issue, and Judge Jenkins took probably 2 months to consider it and issued this order that granting an injunction, not just a temporary injunction, but granting an injunction to enforce the non-competition and non-solicitation provisions would not be an unconstitutional prior restraint under either the United States or the Texas constitutions. There were probably hundreds of pages of briefing from both sides. It was argued at length to Judge Jenkins, and he made this ruling. As a result, those carve-outs are no longer necessary. You may recall that there was a computer at issue. I like to joke that in employment cases, there's always the $100,000 laptop that's worth $1,000. But the Saylor had sued FLOSPORTS for the Stored Communications Act. Judge Jenkins denied that as well. He also denied their motion for no evidence summary judgment on the trade secrets, and I think traditional summary judgment on the trade secrets case that we have filed against Willie Saylor. After the deadline, the production in this case has been abysmal from the defense side. I think it's about 1.5 bankers boxes total for both defendants. But after the deadline to respond to the defendant's summary judgment on trade secrets, they produced a number of things, including leads that Willie Saylor had given to Martin Floreani at Rokfin after he started, and our own targets for FLOSPORTS. They also revealed that they had been using our photo to market Willie Saylor on Facebook. Rokfin creates his image on Facebook and then promotes him with purchased audiences. So you have plenty of authority here to find Rokfin and Saylor in contempt. And Rule 692 applies, gives you the ability to punish with contempt. It's inherent in your court anyway. This is the prior case from the Texas Supreme Court. You have wide discretion in deciding how to administer that. These are the bases for contempt. And each one of these, what I'm doing is I'm going to break down the provision of your order that applies and then how it's been violated. And if there's something AEO, I'll skip over that document. Here's the first provision that the defendant shall not compete against FLOSPORTS by providing services in the sports video industry, including for Rokfin. These are tweets, so they're not going to be AEO. As I said, FLOSPORTS hosted one of the first live wrestling events with major events on July 25th. Willie Saylor at first said on principle he wasn't going to talk about it, largely because some of the women wrestlers decided that they didn't like their pay structure as opposed to the male pay structure. And so he was standing in solidarity, he said, with them by not reporting on it. And then when there was a technical glitch at some point, he joked that he was the one that cut the line. Now, all of these are linking back to his Rokfin for people to subscribe on Rokfin. And when people subscribe on Rokfin, Willie Saylor gets a percentage of their the monthly amount they pay. So this is straight up competition in violation of your order. Then he continues to report on our event, encouraging people to flip over to Rokfin. And this is the worst. Okay, so Mr. Saylor, actually, you'll see, he's also called Matt Scouts. That's his kind of handle, Matt Scouts, that you'll see up to the left corner here. He took this mugshot from a FLOSPORTS employee from 2019. This FLOSPORTS employee got in a domestic dispute at his house in 2019, and then said the reason that FLOSPORTS had a technical glitch in 2020 at its post-COVID wrestling match was because this individual was on a 2-week suspension for having assaulted his wife at our headquarters. None of which happened. No one was assaulted at our headquarters. He had a dispute that was that they declined to prosecute back in 2019. Yet they removed the date off of the picture and tweeted it out to say that FLOSPORTS was anti-woman and that people should move over to Rokfin. This is where the same gentleman who had originally tweeted that said that he now had a common goal with Willie Saylor to take out Flo, competition. Saylor then emphasizes his work at Flo. WNO is who's number one. And he says, that was my baby. Flo's doing a bad job of it, basically. He continues to talk about attacking Flo and wanting people to flip over to Rokfin. And they do. They post about it. They say, I'm going to follow Willie. He's out there. I'm going to go over to Rokfin. And that way, Rokfin gets those subscribers and they pay Rokfin $10 a month instead of paying FLOSPORTS $10 a month. What you'll see is when Saylor began working for Rokfin, Rokfin had fewer than 2,000 subscribers. Right away, their subscribers spiked. This is the bulk of what's happening on Rokfin is wrestling. and the bulk of the posts on Rokfin are from Willie Saylor. Even though they're both under a temporary injunction not to compete with FLOSPORTS through Willie Saylor. You'll see there's another spike of about 10% after FLOSPORTS' own COVID wrestling match. The subscribers to Willie Saylor, because he leveraged that and competed, they were able to add subscribers at that point as well. Okay, I need to clip through that part. So what you're going to see, let me go back. What you're going to see is that Rokfin is using FLOSPORTS to target people on Facebook with Mat Scouts. They're using our name to filter for people who are looking for us. Then they're using Willie Saylor's name to filter, and that's how they're targeting their audience. That is downright competition, and it violates your order. Now, the second thing is they're using these monikers and catchphrases that you specifically ordered them not to use. You may recall the greatest mind in wrestling was one that they used. That was developed at FLOSPORTS. This is from the temporary injunction hearing. When they, okay, I need to get out of that. When the issue came up at Rokfin, and Rokfin's marketing vice president said, you cannot use these monikers, that's when Mr. Saylor responded, I thought about that, and I don't
Your
get.
Honor, I'm going to object. We again have things on the screen that are not supposed to be on the screen.
These are ads.
I'm looking at on the side here, a Nick Villacat using, I mean, this is exactly what you had up in the first place, and I'm going to object to it.
So I'm confused because this is not the same thing that was up on the screen the first time I heard that objection. I do see that at least I have, my screen shows both the main slide as well as preview slides of upcoming slides. Perhaps you need to go to full slide view. And if there's something on this particular slide, then let's move it.
Okay.
Yeah, I can go to full slide view. There's nothing on this particular slide.
It doesn't appear to be, but other slides are also visible. That could be the source of the objection. So perhaps you should just go to full slide view.
There's two on the side that are
Yeah, that's fine.
Oh goodness. Now, hold on. Oh shoot. Okay, hold on.
Yeah,
I gotta get out.
right there.
I gotta get out of it so I can get to the,
I think I have a flavor by way of opening statement in any event. I think we should probably move on.
well, Judge, if I could just hit a couple of more points on this.
You
and
can hit more points. I'm just saying I don't need 5 examples of the same thing. So I'm just saying let's move to the next point in your opening statement. It's not closing argument, it's opening statement. And I think I have a flavor for the concerns that you're raising in your motion.
Yes, Your Honor. And I think that how do I go from here, from this slide, instead of going from, well, okay. So I'll just use it to explain, let's see, where are we? Here. Technology.
Training.
Okay. Does anyone have a go for how I go from here like starting from this slide, full screen?
You might try going over to the preview slides and clicking it.
Okay. Okay. There you
The
go.
next one you want.
Okay.
Not that I can train anybody about technology, but in my experience, if you go over to the slide number, whatever you want, and click on it, it will appear in the big screen.
Okay. So this, you'll see Rokfin. Do you see on the right there? Rokfin has been using greatest mind in wrestling, even though that's specifically what you had said not to do. Then this is July 29th. Willie Saylor tells a woman wrestler that she's, quote, stealing his moniker because she's using greatest mind in women's wrestling. He's probably joking, but it's competition, and it's competition using these monikers. You may hear the defense say that that these monikers are not FLOSPORTS. This is competition, and that's why the court restrained it, and they are completely flaunting that ruling. You'll also recall, like I said before, there are carve-outs that we think are nullified, or they're no longer needed because of Judge Jenkins' ruling on the First Amendment. But they're publishing like crazy outside of those carve-outs. For instance, Mr. Saylor went back and wrote about a 2013 event. The carve-out is for future sporting events. 2013 is not in the future. When he wrote about our wrestling matches in July of 2020, not about a future sporting event. When he wrote about, he's written 114 articles that we put together for the court in just 7 months that violate your order and do not fall within the carve-out. This is a big one. The defendants are hosting fantasy wrestling on Rokfin. Mr. Saylor, you'll see here, right here on the left, Mr. Saylor handled fantasy wrestling at FLOSPORTS, and now he's doing fantasy wrestling on Rokfin. It's not part of the carve-out, it's competition. It's prohibited by the temporary injunction. And again, this is particularly important during COVID because people want content, and fantasy wrestling is some of the content that they want. Likewise, he's still posting, this was from this weekend, still posting recruiting roundups on Rokfin. That's not, you carved out rankings, you didn't carve out recruiting. Those are two different things. Recruiting would be, come to my university. That's not rankings. This doesn't fall within a carve out, and yet they continue on and on to violate. It's always curious to me that they say that I'm not conferencing with them enough about their violations, and yet they happen day after day after day. Video, live streaming, and broadcasts are prohibited. You'll recall that Mr. Saylor testified that he had a non-compete and he wouldn't do any live sports video. And yet there are dozens of examples of those videos that are still up on Rokfin. Rokfin didn't take down anything and left up a lot of video of Willie Saylor. Willie Saylor is also in talks with other people to do live events that he is tweeting about and ignoring this court's order. Saylor and Rokfin were prohibited from publishing any FLOSPORTS proprietary information, yet Willie Saylor has repeatedly tweeted that he is writing a book about FLOSPORTS and that no shut up money can make me stop. Now, this may or may not be part of what you wanted to take up today, because it was not part of our emergency motion, but it was a part of our underlying motion, which is that in the original temporary restraining order and then in your two injunctions, the defendants were to return all FLOSPORTS information other than what Martin Floreani had as a shareholder of FLOSPORTS, because he's still the largest individual shareholder of FLOSPORTS. And so, but instead of that, the defendants retained that information. And on March 10th, 2020, Mr. Brudico wrote that Mr. Floreani has in some, that information, that 12 years of Mr. Floreani's emails at FLOSPORTS, 12 years of his emails at FLOSPORTS had gone to his personal Gmail account, and he had in some sense retained those. And because of that, he gave it to Rokfin's counsel. And then this says, and this firm has been holding the materials for some time as a courtesy, with no notice to FLOSPORTS that he still had that, or to the court that he had that. These are texts from an independent IT individual who now works for FLOSPORTS, that he was doing a giant migration for Mr. Floreani back in 2018. And that was permitted. He was allowed to take his emails with him at that time. And then later he signed a severance agreement that said he would only keep what was consistent with his duties as a board member. He remained a board member with a fiduciary duty and a shareholder. But then in April of 2018, he loaded those emails, 12 years of FLOSPORTS emails, to Rokfin. We didn't find that out until March of this year. And we know that a temporary injunction, not only does this temporary injunction specifically reference Martin Floreani and what he can retain, but it's binding upon the officers, agents, employees, and attorneys. So we're asking that you expand the temporary injunction and that you extend it until we can have a trial. And like I said, we're willing to do that as a bench trial, and that you sanction the repeated contempt. You'll recall that the reason for those carve-outs were free speech concerns. That was what really drove our discussion around how you were going to change from the temporary restraining order to the TI. The defendants sought summary judgment, as did we, on that point, and because they said it was an unconstitutional restraint. And they specifically said, this is from the defendant's motion for summary judgment, that you had the basis for the carve-outs was because of the First Amendment. As you know, that concern has been alleviated by Judge Jenkins' ruling. And this is a non-compete that expressly provides for extending during the time of violation, which there's no question that Mr. Saylor has been in violation. You also have the right to do that equitably, and under the Trade Secret Act. I will note that I've seen some defense pleadings that because of COVID, no one can be damaged anymore. And so not only is content more important than ever because of COVID, but in these cases where you've got a non-compete, in these cases where you've got the Uniform Trade Secret Act, and in these cases where you've got tortious interference, irreparable harm is presumed. And we are experiencing irreparable harm when Willie Saylor takes our big event weekend, takes a doctored photo of one of our employees and tweets like crazy and uses Rokfin to flip our customers over to them, as well as using fantasy wrestling and recruiting in direct violation of this court's order. Thank you for your patience with my technology and everything else. And when we get to evidence, I'd like to call Willie Saylor first.
All right, thank you.
I will unshare.
Ms. Sticky, are you taking the lead for Rokfin?
I'm talking for Rokfin. Mr. Hayes is going to talk for Mr. Floreani, and where did he go? Carlos is going to talk for Willie Saylor. Your Honor,
I understand that. My question, though,
yes, I'm taking the lead.
There's you and 2 or 3 other lawyers on your side. I'm just asking, among those 3 people, are you taking the lead?
Yes.
Okay, then you may proceed next.
And Your Honor, just to clarify, to understand, obviously I represent a different defendant and target of this. So I also have an opening I would like to present in addition to whatever Ms. Dickey does for Rokfin.
No, 1 person for Rokfin, 1 person for Floreani, 1 person for, 1 person for Saylor. So I didn't understand what you just said, Mr. Soltero. I thought you represented Mr. Saylor.
That's correct, Your Honor. I just wanted to be clear that what Your Honor was saying, now with what Your Honor just said, you clarified exactly what I was hoping to clarify, that I was going to get an opportunity to do an opening on behalf of Mr. Saylor separately from whatever Ms. Dickey may do for Rokfin.
Okay, let me clarify why I asked Ms. Dickey the question that I asked. When she made the announcement this morning of counsel, she listed 3 people for Rokfin, for Rokfin. And I'm simply asking her, of those 3, who's going to talk? Me. That has nothing to do with the, say, 2 people, Hayes and Weisbart, who represent Floreani. Only one of them is going to get to talk, not both. So I'm just asking each side to identify one lawyer to represent that particular party, and only one lawyer is going to be articulating argument and asking questions for each side, or at least argument. You can
Judge,
switch off lawyers if you wish, if you're going to take responsibility for defending or offering testimony through witnesses. But for opening statement, one lawyer per side. Ms. Burgess, what's your question?
Yes, Your Honor, if our emergency motion did not include the Martin Floreani emails, if you want to take that up at a different time because of time, then probably Mr. Hayes and Mr. Weisbart would not be wanting to speak. But I don't want to speak for them. I'm just willing to move that chunk of it over if that's something that would be better for timing. But
I guess I don't quite understand. Does your emergency motion include complaints about Mr. Floreani or not?
no, not my emergency motion.
Your Honor, her emergency motion incorporates her entire original motion. And she mentions it in her emergency motion. Mr. Weisbart has carved time out of his schedule to be here today, and we intend to get to that. Thank you.
Okay, great. I'm fine with that. I was trying to come up with a helpful solution.
Always helpful. Thank you.
Ms. Dickey, you may proceed with your opening statement.
And Your Honor, I'm going to try to limit this to an opening statement rather than an opening statement and a closing statement, because I think that is more appropriate after the evidence is on. What we have here is a continuing pattern by FLOSPORTS to have a war of attrition against Rokfin and Mr. Saylor. They have, for the last now 9 months, filed one motion after another, including, essentially, they filed 2 motions here demanding an immediate hearing on an emergency. This is about high school wrestling. And I don't mean to hurt Mr. Saylor's feelings, but this is about 12 and 13 and 14-year-olds wrestling. And he makes $45,000 a year when he can writing about this. It is not the be all and end all of what FLOSPORTS does. And it's really puzzling to all of us why they are spending hundreds of thousands of dollars full-time making a big deal out of this. We're going to go into the evidence. We do not believe that anyone has violated the injunction in any way. We believe that counsel for FLOSPORTS, as they have from the very beginning of this case, taken a very overly aggressive view of what the court ordered. We think it's quite clear, but they constantly argue interpretations of this court order that are not in sync with either the written words in the order or what you apparently said during the course of crafting the order in conference with the parties. They rely on the premise that that your whole ruling and the carve-outs had to do with your concern about the First Amendment, that you insisted we run off and file a motion for summary judgment on it, and that Judge Jenkins ruled in their favor. And if you look at the very, very short order that Judge Jenkins issued, it's not what it says at all. He basically says that the injunction that you issued in this case did not violate the First Amendment. He didn't make a definitive final ruling on that. Prior restraints is still good law. He didn't opine that you can expand that injunction. He didn't do any of that, Your Honor, and I'm sure that you have access to his 4-line order and can look at that yourself. But what they're arguing, as I understand it, is that we need to start over. And because Judge Jenkins said that your order didn't violate the First Amendment, that then you can move on and sort of do anything you want. In our response, Your Order, we have outlined this, but the problem that is rife throughout this is that Ms. Burgess's and FLOSPORTS' position is essentially that Willie Saylor can't do anything. He can't, the court order said he could write about future sporting events, but their very twisted interpretation of that means that if an event is coming up, he can write about it, but once it happens, he can't say a word about it or during it. That simply cannot be the correct interpretation, and it's not consistent with the things that I've seen that were in emails and the recollections that I've seen that various people have written down about what you were trying to do. Their whole purpose in this is to completely sideline Mr. Saylor, not allow him to make a living, and through litigation, Your Honor, essentially crush Rokfin. The best example, actually, Ms. Burgess put on the screen, which is they have an upcoming Who's Number One contest coming on. And Mr. Saylor is writing about the Who's Number One contest. That, in essence, in my opinion, the fact that he's out there writing about a future contest and what's going to be involved promotes FLOSPORTS. It's a live event. Mr. Saylor doesn't do live events, but he's entitled to engage in journalism and write about things that are happening. And what he's writing about is what their matchups look like and how that's going to come down. And I don't believe under this injunction that there is anything wrong with that. The other thing that they have taken to an extreme, Your Honor, is that the court ordered no use of monikers and catchphrases. There was no specificity of that. We know that's Who's Number One. They trademarked that, I believe, or whatever that you copyrighted or patented or whatever you do last December. But the other phrases, big board, I mean, I watch, I have to admit, more CNN and MSNBC and Steve Kornacki than I should. Steve Kornacki has the big board. The Wall Street has big board. Everyone on the planet uses big board. And so what we have here is a really broad over interpretation of what we were supposed to do. I don't think it was the court's intention when we started, when the parties started down this path last January, that this should last for 9 months. The court set it for an early trial because of all the concerns for March and then May. It's a brave new world out there. It's a Zoom world out there where things are simply not happening. We're all balancing many, many things. FLOSPORTS is hurting, I'm sure, because there are no live events, and they are in the video production business for live events, Your Honor. That's not the business that we're in. We're a platform where we allow people to go on the platform and post things and write things and do things. It's a completely different model. It's a completely different set of premises. I mean, on Rokfin, there's lots of things besides sports. So, you know, that's kind of where we are. One of the things that she reviewed, and again, Your Honor, I hate to go into closing when we haven't even heard the evidence yet, but one of the things that she reviewed is that that we're violating the order because he did not take down videos that were already on his site, which the court clearly did not order him to do. They constantly reference those videos that were there before the last hearing. No new videos have been posted, and there's nothing in the order that required us to take it down. Mr. Saylor is not working for Rokfin. He's a content creator, like 40 or 50 other content creators on the site. And I'm going to allow or ask Mr. Hayes to address the entire issue about documents and what's in Mr. Floreani's possession and who and where. But Your Honor, what I would say just in opening is that the overreach of this lawsuit that is about a guy that writes about high school wrestling and makes $45,000 a year, to turn it into $1 million lawsuit just in attorney's fees is something that is a method of competition that we can show, and it will need to be AEO, that they crafted starting last September, Your Honor, and have deliberately pursued in order to burn up Mr. Floreani's time, to interfere with his new company, to hurt him. And Mr. Saylor is merely a pawn in all of that. Your Honor, I would again urge that Ms. Burgess, 20 minutes before we start this hearing, filing our witness list and saying she's going to put on our witnesses is completely inappropriate. If she was going to do that, we filed ours yesterday at 3 o'clock. It took about 30 seconds. And to this morning devise a strategy to preempt us on our witnesses should not be allowed by this court. So I will have more comments. Will probably be next week when we finish this, but that's our opening for Rokfin.
Your Honor, may I proceed?
Mr. Soltero is next.
Thank you, Your Honor. Carlos Soltero on behalf of Willie Saylor. Plaintiff's motion, Your Honor, even from the claim of being, quote, an emergency, particularly given the reality of the times that we live in, is not only disproportionate and seeks draconian relief that's unwarranted, but the whole tone of the motion, and frankly, again, the PowerPoint presentation this morning with slides mostly made up of things that happened before last time that Your Honor had an injunction hearing. So it couldn't possibly be related to a violation when they happened back in November, is calculated to incite panic and alarm to the reader and to harass Willie Saylor, which is what has happened nonstop since he left. Sending a private investigator to his house, the way they've managed and handled this litigation. And we are here, we were hoping to get testimony on, and we want to address any concern or question that the court may have about any potential violation. I'll say the motions are unnecessary, they're without merit. And I think that the court's January 6th injunction, which did not happen in a vacuum. I mean, there was a context to that. The plaintiff submitted a completely overreaching and inappropriate one. Your Honor was traveling. And Your Honor got on the phone with all of us and corrected it and entered the order which we have and we've been abiding by. At the time, we also discussed an initial trial setting. And the idea was that this is pretty restrictive and it's gonna be a short period of time, late March. Nobody anticipated COVID. It's now gone way beyond March. This case was set for trial Monday, this Monday coming up, August 31. Obviously, that's not happening because of a number of reasons. And on behalf of Mr. Saylor, I'm asking the court for 3 basic things. 1, deny the relief requested by the plaintiff. Our written response, which is extensive, and the exhibits there, plus what we'll have today as evidence, and next week, will show the court why relief requested is unwarranted and improper. Number 2, we'd ask the court to dissolve the injunction. The time has passed. It'll be a year around election time. And whatever was appropriate or needed in January is no longer needed. And I'm going to talk about the trade secret portion of it in particular in just a little bit. And number 3, we'd request that the case be set for a new trial date and then hear the number of issues that we have in dispute on both sides relating to this case with conferring beforehand. And lastly, Judge, one of them as an example only is that they've designated almost every document produced as if it were AEO of FLOSPORTS, tens of thousands of pages. And so my client can't review it to defend himself. And so those are the kind of things that we think need to be addressed at an appropriate time. Your Honor, if I may proceed, So case law tells us that permissive relief in lawsuits is framed around pleadings. And so one important thing to keep in mind, Judge, is what do the pleadings actually say in this case? What do they say? What do they not say? I'm going to start with what they don't say. There's no claim of trademark infringement. There's no claim of copyright infringement. There's no claim of patent infringement. There's also no claim of defamation or business disparagement. What they do sue my client about is allegedly being a thief, of stealing trade secrets and misusing them. And secondly, that he has this restrictive covenant, to be narrowly construed, the PIIA, which would have kicked in November 3rd and would end November 2nd, 2020. Mr. Saylor, as your honor knows, and as they've said all throughout this case, was an at-will employee. And if FLOSPORTS thought he was that valuable, important, they could have locked him down for a number of years, like I know Mr. Saylor for a fraction of what the Kansas City Chiefs signed Patrick Mahomes for, a small fraction, would have been happy to, enter into some kind of contract perhaps, but that didn't happen. The claim against Rokfin is tortious interference. That's the only one. And the reason I mentioned the pleadings, Judge, I know you know this, but it's super important because what the plaintiffs do over and over again is they take a piece here, a piece there, they mix and match, and nothing flows straight through, nothing actually holds up when it's analyzed and looked at. For instance, you will recall, and it's Defendant's Exhibit 2 that's already been submitted with our filings, and it's here in the box filings that your honor requested. Mr. Machuca testified that Mr. Saylor's access to Periscope and all these trade secrets that they're talking about were cut off within days of him leaving. So as of even the time we got before your honor, he's had no access to these trade secrets. And so there's absolutely no reason or basis to continue to enforce something where there's no fear of any irreparable harm, no realistic concern about that. Also, Judge, in all the documents they produced, there's zero basis that I see for any claim whatsoever in these of any violation on trade secrets or any damages. I will say also that many things that we've heard this morning, we've heard throughout this litigation that have been filed against my client are taken out of context, they're distorted, and also they complain a lot about things Willie may say. He said this, but he hasn't really done anything that is a violation or harmed or violated the injunction. And again, let me emphasize, Judge, and I can't emphasize this enough, and I would say every time that Ms. Burgess or FLOSPORTS puts a document in front of your honor, I think it's important to know what's the date on that document. Because for instance, some of the things they were showing all were before the court entered the injunction. These videos that they complained about, all of them were before the court entered the injunction. That would be something I would say is very important to keep in mind. Also, Judge, because this is an equitable proceeding, that is important. When the evidence that is being brought is not any violation of an injunction, it's things that existed already beforehand. I want to address a couple of others kind of at a high level and let the testimony speak for itself. But this event in Oklahoma that they're complaining about, what happened here is simply this. A father of a wrestler asked Willie Saylor if he would help get the word out about a potential wrestling event. One, it never happened. The event didn't take place. Second, this was pro bono and not something that Mr. Saylor was getting any compensation for whatsoever. So it's not competition. It's all laid out in Defendant's Exhibit 3. Second, with regard to moniker, again, Ms. Burgess omits what the order actually says that your honor signed, which says the use of monikers and catchphrases created at FLOSPORTS remains prohibited. The vast majority of everything they're complaining about are things that were not created at FLOSPORTS. And there's considerable evidence we put in the record on that fact. And the term's not even defined. Lastly, with regards to a couple other points, future events. So their construction of your honor's order is that he wasn't allowed to write about anything other than what could possibly happen in the future. In essence, to have a crystal ball. In fact, what your honor's order plainly says, as Ms. Dickey referenced, is that he was to write about future events. That means things that are coming up and things that happened after January 6th, 2020. And that's exactly what he's done. Now, do we sometimes, in terms of writing about an event that's currently happening, reference something that happened in the past? It's possible, but that is not a violation of your honor's order. With regards to the Mr. Helton and tweet, let's put this in some context. Mr. Saylor didn't didn't do that. First of all, didn't create that mugshot and wasn't the one who tried to forward any of that. All he did was make a tweet and a comment response. And then let's look at the underlying facts. Again, there's no defamation or disparagement claim in this case. The tweet at issue, if you look, Your Honor, at exhibits 9 and 10 in the box that are there, we've already filed. There are certified court proceedings of the actual arrest. There's no question that it was assault with injury. Mr. Helton was arrested. And on page 2 of defendant's exhibit 10, it is clear that the report says he hit his wife in the face with a closed fist and left a small red abrasion, okay? Then he denied it to the officers. Now, it's unclear what FLOSPORTS ever did about that, whether they put him on probation, whether he's been reprimanded, who knows? But tellingly, they've never asked us for retraction. They've never said that that wasn't true. What they've said is that what Mr. Helton did, I think or Mr. Mineo did, is that he put that together with a problem they had with their event and tweeted about it, that maybe this is why. And all Mr. Saylor did was say, that would make sense, or something to that effect. Your Honor, because this is an equitable proceeding, because of the nature of this really bad blood, really nasty approach to litigation and to former employees that they've taken, I'll note that FLOSPORTS does not confer before filing. And why does that matter? I'll tell you why. If you look at defendants, well, one, because the rules require a judge, and because that's what we do here. And for that reason alone, I think all this relief could be denied. But defendants exhibit 4, we've attached a letter that when they filed this motion and started raising these issues, we responded to them. And then we said, look, we don't think you're right about your interpretation of what Judge Livingston ordered, but regardless, we're going to tell our clients to just not post anything at all. That should be the way we do things and resolve things. And so, but the truth is, Judge, the hard, absolute truth is that they don't want to fix and they don't want things to be done an appropriate way. What they want to do is get a bunch of gotchas, take things out of context, complain, and then they want to punish, and they're looking for vengeance against Mr. Floreani and against Mr. Saylor. As a note, Judge, of what things they're, the way they do things, we attached defendants exhibit 7, which is also in the box. It's been filed of record, where after we had a lengthy, and I think Your Honor may remember, it was about 30 minutes, we were all on the phone. I was at a hearing with Judge Jenkins, and then I went down and attended the hearing by phone, even though I was at the courthouse. Your Honor was very clear about the injunction and about the early trial setting and all these things. But within days, apparently plaintiff's counsel contacted your staff, Mr. McCabe, and tried to get, quote, clarification or try to enforce this. It's laid out in defendants exhibit 7. Your Mr. McCabe correctly responded that the order speaks for itself, and if there's a problem, to go to the central docket. But this is just an example of how this case has been handled from day one, and FLOSPORTS certainly doesn't have clean hands or has acted equitably to be able to be entitled to equitable relief. Last major point, Judge, in my opening and what I think the evidence will show, there's no harm to FLOSPORTS. One of the things that all the case law says is that any kind of sanctions or relief has to be proportionate, and there has to have actually been harm to the person seeking it. There's no harm. I'll tell you, there's no sign I've seen of any actual monetary harm or damages by anything Mr. Saylor has done. It pales by comparison with the amount that's been inflicted on the defendants by costs and attorney's fees. Also, as we put in exhibit 2, which is not AEO, there's also some things in exhibit 1, which is AEO, but exhibit 2, Mr. Machuca testified that live sports streaming is the overwhelming part of Flo's business. That's not happening, and none of that has been done by Saylor. We also have laid out, Judge, that the harm that has happened to FLOSPORTS is because of COVID, there are no live sports to stream. That's, if anything has harmed them, it's been, number one, that. Number 2, they've had a lot of problems about the way they've treated women wrestlers and there have been other issues unrelated to Willie Saylor. And also, they have never, Judge, ever made a profit. So the idea of coming in here and seeking a claim for lost profits is shocking. And this is also public information. FLOSPORTS got millions of dollars in PPP money. And so, Judge, when you're looking at what's equitable, what's right, and whether there's been any harm, there has been none. And so far, there have been only 2 depositions in the case, Judge, Mr. Noonan and Mr. Villaquette of Rokfin. I want to thank Your Honor for giving us the opportunity to be heard. to listen to the testimony, and we would respectfully request that the court deny all the relief sought by the plaintiff. We would request that the court dissolve the injunction and set the remaining part of the case for trial at an appropriate time. Thank you, Your Honor. And I'll have any questions and, of course, our witnesses that we would like to call.
Thank you. Mr. Hayes or Mr. Weisbart, which of you is going to make the opening statement for Mr. Floreani?
Your Honor, this is Butch Hayes. I'll go ahead and do that.
All right. Thank you. You may proceed.
All right. Thank you. This has all been very interesting to me, but my part of it is relatively finite. And it involves, Your Honor, the existence of emails that were given to my client, Mr. Floreani. I have been involved in this case since about March 10th of this year. So when I came in to represent Mr. Floreani, I had to learn about the injunction and had to learn about the history of all this. Here's what I learned. And all of what I'm about to say is going to be supported by the witnesses and the documents I'll point to the court. So what I learned was that Mr. Floreani was the CEO of FLOSPORTS for 12 years. And in February of 2018, there was a board vote to move him out of the CEO role. I learned that at that time, Mr. Floreani's brother, Mark Floreani, who is the current CEO of FLOSPORTS, approached my client, Martin, and said, hey, I want you to have your emails. You've used your FLOSPORTS email for all your personal stuff for 12 years. It's all your stuff. We just take it and don't worry about it. It was, to be clear, FLOSPORTS initiative. They came to Martin and said, we want you to take your emails. Also, Mr. Weisbart, my partner, will testify that he engaged with Mr. Herdlow, who was the general counsel of FLOSPORTS, and they negotiated several things, but one was Martin Floreani would get his emails because he was, at that point,
Mr. Hayes, I don't have any understanding about what this email business has to do with the contempt and sanction motion before the court.
Sure.
I confess I've not read it entirely because I just got this gigantic notebook at about 8 o'clock last night when I went down to the courthouse after everyone else was away from that building so as not to interact with other individuals. But I don't see in any of it, and nor have I heard anything so far that has anything really substantive to do with the emails. I know that Ms. Burgess mentioned that in her opening, but I don't know what it has to do with the motion before the court today. So help me understand what that has to do with it.
Sure. In the emergency motion, FLOSPORTS does not mention this issue, but we've all
Okay,
prepared.
so then we can skip right past it because I'm only taking up the emergency motion. So what, if anything, does Mr. Floreani wish to tell me by way of opening in connection with the motion that I am going to take up today?
Well, I suppose he will absolutely talk about the nature of Rokfin and FLOSPORTS and what it does and why. I presume what Mr. Saylor has done is not a violation of the temporary injunction.
Is Mr. Floreani the subject of this motion for sanctions? I thought not, but
He's not. The reason I'm here is that there has been this back and forth between Ms. Burgess and I about these emails, and she claims that the emails are Rokfin's. We claim that the emails were given to him as a shareholder and he's properly in possession of them, and that they're his personal emails interspersed with FLOSPORTS emails. And I'd like to resolve that. I've tried to resolve it. I've filed.
I'm sorry to interrupt, but I just want to get some clarification. Mr. Floreani is not the subject of the motion for sanctions and motion for contempt today, correct?
Not personally, no.
Okay.
Your
All
Honor,
right. And is Mr. Floreani the subject of any other written motion? And if so, what is the title of that motion? Who filed it? And what day was it filed in the court file, please?
Sure. Mr. Floreani is, I think by implication, the subject of it. And it wasn't the emergency motion. It was the motion previously filed, Karen. It was in June or so when you filed that, and you mentioned this device with the emails on it.
Wait, I'm sorry, what motion are we talking about filed in June that implicates Mr. Floreani in some way directly?
Your Honor, if I may, because I have it in front of me, In the emergency motion in footnote 2 on page, or footnote 1 on page 2, it references the June 8th, 2020 motion to show cause and for sanctions and to amend the temporary injunction. So by its very nature, her emergency motion incorporated the motion that she filed on June 8th. In the June 8th motion, she specifically, FLOSPORTS specifically raises the issue of these emails, their failure to return them as one of the points of contempt.
What is the title of the June 8th motion?
It's FLOSPORTS motion to show cause and for sanctions and motion to amend temporary injunction. So it's essentially the same motion, but then later, when she files this one, she calls it an emergency. But that one is completely incorporated into the current motion, Your Honor. And in that one, she raises it extensively as to what was not returned to them, and that is contempt of court. And they are Mr. Floreani's emails, and that's why Mr. Hayes is here. So I'm sorry, I have that in front of me, so I thought that would help the court.
Oh, that's very helpful. Thank you. Okay. Well, I see now why there was confusion about what was whether or not Mr. Floreani's counsel might need to be here or not be here. So I guess I need to circle back for just a minute to Ms. Burgess. I understood that the only thing we were taking up today was the emergency motion for sanctions and contempt. But then I did hear in Ms. Burgess' opening statement, among other things, this request to expand the TRO, and which sounds like that might be related to the June 8th motion to amend the temporary injunction, or expand the temporary injunction, I should say. And so I guess I need clarification about what actually we're doing today, and if not to finishing up today, next week. Are we going to be talking about a request to extend the temporary injunction to include some issue related to this email issue? I guess that's my question. Or what's the point? What's the point of your request related to these emails? What request, if any, are you making? And what's the relief you seek in connection with these emails?
We asked for that in the underlying motion, and I could not tell, but what was said on the docket, what the court said, this wasn't a traditional setting. What the court said was the emergency motion. So I didn't know whether you wanted to take that up or not. I saw that Mr. Hayes was doing things to making moves towards defending that issue, and I'm happy to take it up or not take it up. It's not the kind of emergency that, say, posting recruiting on Rokfin last weekend is that directly violates your order. We do need to take up the expanding and extending of the injunction, because that is, as they said, by agreement, actually the defense asked to move the trial date back, and we did, and it was set to start Monday. And so right now, the current way that the TI reads, we have a backup date too. So it either expires at the end of 2 weeks from Monday or at the 1 month from then, depending on which trial date we got. And so,
my question, let me interrupt you. My question is simple. What is the relief you seek in connection with the email issue that Mr. Hayes is telling me about? What's the relief that's being sought in your underlying motion filed in June?
Sure, that would be the contempt, because they didn't turn it over when the court 3 times ordered them to turn it over. But also to have them actually turn it over, not as a discovery request where they keep it, but rather the order says that they shall not retain that information. And so we want them not to retain 12 years of FLOSPORTS emails.
Which is why Mr. Hayes is here making this argument, because the emergency incorporates the June motion in its
entirety. You told me that already. I got it. I think I understand now. That's helpful. Mr. Hayes, you can go ahead and proceed now that I understand it. We're going to just deal with here, we'll just deal with it. Everybody's here. We'll get it figured out. I don't want to have to keep coming back to issues that involve potential violations of orders and contempt. If it's related to the contempt, whether it's an emergency or not, since we're going to spend 3 hours this morning talking about it and 3 hours potentially on another day talking about it, we might as well get it all done in one fell swoop. So,
Thank
Mr.
you.
Hayes, I apologize for the interruption. You can, now that I at least have context for what you're talking about, I'm now prepared to hear more of what you're telling me by way of opening, if anything.
Fair enough. Thank you. I apologize for the lack of context. I would, and thank you for letting me speak about it, because I really would like resolution on this issue. It's been out there for a bit. So I came into this in March. I learned several things. One is that Mr. Floreani was the CEO of FLOSPORTS for 12 years. And when he left at the time, February of 2018, his brother approached him and said, look, Martin, I know you have used your FLOSPORTS email for personal matters for the last 12 years. Just take your email. That was, and he was fine with it. And that's Ms. Mark Floreani, who's now the CEO of FLOSPORTS. Jeff Weisbart, my partner, represented Mr. Floreani in his exit and talked to Mr. Hurdlow, who is the general counsel of FLOSPORTS. They negotiated that because of, and I think we'll get testimony on this, because of Martin's status as the major shareholder. Look, take your emails. It's okay. They had a severance agreement at that time, a couple months after he left. And just in contrast to what Ms. Burgess has said, that document, which is exhibit number 1, Floreani exhibit 1, in the box, I believe, specifically calls out the emails that were given to Mr. Floreani. And I'd like to read that provision because it sets the tone, it sets the context for what the court is addressing now. And again, this is a document, the severance agreement from April of 2018, which I'll read only in selected part right here because I know it's confidential. By signing this agreement, you, Mr. Floreani, acknowledge that you do not have any company, property, or proprietary information as defined in the PIIA in your possession, except to the extent provided to you by the company since the effective date. That's February 18th, effective date. And his emails were provided after that date. Or necessary or consistent with your duties and role as a board member and shareholder of the company. Nor have you failed to return any previously requested company property or proprietary information of the company, including but not limited to access cards, keys, computer equipment, including laptops, except the currently used laptops that you're using, software and printers. So when he left the company, everyone knew he had these, and everyone knew that this document accepted those from the duty to return, okay? And there were conversations about this negotiation. Now, that's the context. No one asked him for these emails. They included family stuff and children stuff and his life for 12 years. No one said anything when he left. No one said anything for, and a year later when he announced he was starting Rokfin, no one asked for him. Only when this lawsuit started did this become a hot potato. So I jump into this case as his personal lawyer in March of this year. And one of the first things I do is I receive from Mr. Brudico's firm, which was representing and still does represent Rokfin, this basket of stuff. And they include old wrestling videos and various articles. And anyway, I make a copy of all of it, including a device that, and it's the only copy of it, that includes these emails, which are his personal and some FLOSPORTS emails for 12 years. So I make a copy of, or I hold it for a long time, but one of the first things I do is I write, and this is exhibit number 2. On March 10, I write to everybody and I say, counsel, our firm represents Martin Floreani. This is the day after I was retained. I've confirmed that the materials identified below and described by Mr. Brudico, is what I've described to you, have been transferred to us. I understand that no other copies exist. We intend to maintain exclusive custody of them until and unless directed otherwise. Okay, I don't hear anything. And then in the same day, actually the next day, I write to Ms. Burgess, and that's Floreani exhibit number 2, explaining more context, just she and I, about the documents. And I receive a very nice voicemail from Ms. Burgess, but instead of addressing these emails, it's about, we're going to sue your client. Do you want us to sue him in a new case, or do you want us to sue him in the existing case? And at that point, Your Honor, I hear nothing for 2 months about this, not a single thing. Again, I'm still waiting for direction because I'm in the middle of this thing. And apparently what's happened is that there's a discovery dispute over this device with the emails on it, and it's pending. So I'm in the background. I believe that these emails were given to him as a shareholder and as a result are carved out of your injunction. I am being told that by witnesses, and frankly, the documents suggest that. And the next thing I know is I get forwarded a motion. This is the motion the June motion you just heard about from FLOSPORTS for sanctions and show cause and all this because of this device. I'm like, okay, well, let's do this. I'm going to make sure you get the copy of it. I write again to Ms. Burgess. And if you look at the June 22nd letter, which is Floreani exhibit number 3, I try to work this thing out. I'm like, okay, well, I'm going to send this thing to you. I'm going to give you everything I have. But the problem is, at this point, that device, which presumably contains FLOSPORTS and Martin's personal stuff, is encrypted, and no one can unencrypt it. We've made a forensic image. Apparently, our outfit can do that. And I'm going to send it over to you. If you know it, how to unencrypt it, let's do that. That's fine. But I got to protect my guy's personal emails, which was not contemplated at all by the judges, by Your Honor's injunction. And frankly, these things were given to him as a shareholder, and that's exempted out of the temporary injunction. Instead, I say, look, I'll do whatever you want. We'll leave it with the forensic company. I'll give it to a third party. Let's just make sure we have somebody neutral holding on to this because it's my client's stuff. Nope. Give it all back to us. Then we'll talk to you. Well, this is a company that's now threatened to sue my guy for something, which I still haven't heard about. So I give them the device, and right now the data that presumably is in that device that we cannot access and I cannot segregate in terms of FLOSPORTS versus Martin's personal stuff is in the custody of the third party that we have hired. I don't have it. I've made very clear all along, and his affidavits are clear, that no one's accessed this stuff, certainly since I've had it. I understand no one accessed it since his lawyer had it a year earlier, well before this litigation. Martin has signed affidavits establishing that he has not used it as any part of Rokfin. And so I filed a motion to, kind of exasperated with the whole thing. I filed a motion with the court asking to put it in the court's registry, just so I can protect my client's private life and not give it back to the company that gave it to him and that wants to sue him. So that's the full context. I heard something from Ms. Burgess about they didn't know that he had these things loaded onto a device until this year. They knew he had it because they're the ones who gave it to him. Their guy is the one who transferred in full view of the CEO of FLOSPORTS, his brother, all of this information to the device. So I'd love to have some direction here. I think it's fair for him to be able to keep his personal emails. I don't think that this emails I've given him fall within the court's order. And I have witnesses here to explain that. And so I want to ask you to just deny that relief. It's his stuff. He ought to be able to keep it. It's made weirder and more difficult by the idea we can't access it. But I'll bet you anything that FLOSPORTS must have kept a record of what was transferred to Martin. So they know what's on it. I don't.
All right, thank you.
Thank you.
So the last hearing that I had with you folks, at least that as I recall it, the last interaction before the case was assigned to me, believe the only parties were FLOSPORTS, Rokfin, and Saylor. Has that changed? Have the pleadings been amended to include Mr. Martin Floreani or anybody else as a party, or does the case remain with just the three parties? Let's-
Remains just the three.
Okay, so we just have as parties to the litigation, FLOSPORTS is the plaintiff and Rokfin the entity and Mr. Saylor individually as parties, correct?
That's right.
Yes.
Okay, so we'll get back to Mr. Floreani in these emails later, but I'm not entirely sure how I might hold him personally in contempt of anything since he's not a party and subject to any of my court orders, but we'll get to that in a minute. Right now, the most important thing that has to happen is I have to give the court reporter a break because he's been very hard at work and deserves one. I suspect you all might enjoy a bit of a comfort break yourself, so we'll be in recess for 10 minutes. And for the 10-minute period of time, I'm going to go into chambers. You may either stay here in the main meeting, and if you do that, if you would please mute your microphone and turn off your video, that would be helpful, and we won't be treated on YouTube to whatever you do on the break. And in 10 minutes, we will pick up again.
Thank you, Judge.
This court is now in session.
Judge,
Everybody's on mute.
I think we're missing
Judge.
some.
Oh,
I think we're missing Mr. Hayes and Mr. Saltero.
I did leave let Mr. Saltero in earlier, but I guess he must have left again. Judge, you're on mute.
I will call him. Hey Siri, call Carlos Saltero.
He was here a minute ago.
Your Honor, everyone's back.
Except Miss Dickey's now lost.
Lord.
She should be back on a sec. Sorry about that. I thought we were automatically back in the room. I apologize for the delay.
Okay, now it looks like everyone is back and ready to go. Ms. Burgess, you may call your first witness.
Sorry about that. Plaintiff calls Willie Saylor.
Mr. Saylor, you're on mute.
Thank you, sir. If you will raise your right hand, I'll swear you in. You solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth.
I do.
State your name for us, please.
My name is Willie Saylor.
You may proceed.
And Judge, when we want to put exhibits up, will Mr. Bouchron need to share screen to do that?
Yes.
Okay. And so Mr. Bouchron, you ready? I'm going to take it from your avatar that you are.
This is Eric, and I need permission to share the screen if I may.
All right.
And Your Honor, would we be given the opportunity to see an exhibit before it's shown either publicly or to the witness?
You can look at it in the box folder if you want.
Okay.
I'm assuming you all are familiar with them. If there is a question about any of the exhibits, then certainly we can talk about them, but while they're not being shared. But I'll ask everyone to identify by exhibit number the exhibits you intend to
Oh, man.
offer, and if there's to be an objection, I'll have to rule on that objection. And if it's necessary to take it down while we do so and view it simultaneously, I guess, in box, we can try that as well.
Great. The first exhibit that I'm going to use is plaintiff's 13. The defense objected to that earlier, but they did not ask when we moved. They didn't move for the sealing on it. And so it's actually just the document where Mr. Saylor expresses his thoughts on the court's order.
In Your Honor, I object to the characterization. That is not what that document is. And also, frankly, I think we would object on the grounds of relevance.
I don't even know what it is. How about we get the witness started first, and then let's start talking about that. All right?
Yes.
Proceed.
Good morning, Mr. Saylor.
Good morning, Mr. Burgess.
Judge, you understand that Judge Livingston ordered you to stop using monikers, FLOSPORT, monikers created at Flow, correct?
Yes, ma'am.
And isn't it true that you became the quote greatest mind in wrestling at FLOSPORTS?
I tweeted that once and it stuck. I don't know. People started referring to me as that.
And that was during your time at FLOSPORTS.
That's correct.
In fact, at FLOSPORTS, you went from 69 followers to 22,000 Twitter followers.
Yeah. I don't know that I had Twitter before I went to Flow, to be honest.
Right, but you admit that they took you to 22,000 Twitter followers.
They took me. Nobody else there has 22,000, so I like to think I did something right on my own.
Well, and you were a salaried employee, correct?
Yes.
And FLOSPORTS put you on air, correct?
Mm-hmm.
Is that a yes?
Yes, I'm sorry.
In fact, you tweeted recently to Julia Salcata that you ran the ship at Flow, correct?
At one point in time, I oversaw Flow Wrestling as site editor, then as managing editor.
And FLOSPORTS sent you to Croatia a number of times and other places all over the world.
Yeah, I visited. I went to cover several events overseas.
And you had access to Periscope, which tells us who clicks, who engages, who subscribes, correct, at FLOSPORTS?
Yes, I had access to that.
Okay, and we know that you accessed it after you went to Rokfin, correct?
No, that's not true.
You don't admit that you accessed it. Your usage spiked at the end, right?
My usage spiked at the end. My usage, I was not at Rokfin when I accessed Periscope for the last time. No, that's not correct.
You had already taken the job at Rokfin and left FLOSPORTS.
No, I had not.
Okay, we can look at that date in a little bit.
Yeah, well, I actually saw the slide that you put up. If you show the slide that you put up earlier, it was November 3rd. That was the morning after I quit. And that was the last time I accessed it. That was long before, that was several days before I had moved on.
You knew you were going to Rokfin, right?
I thought about it.
You had already accepted a job as a W-2 employee, correct?
Not on November 3rd, no.
What day did you accept it?
I don't know. A few days after that. A couple days after that.
And Mr. Floreani, Martin Floreani, had been recruiting you since February of 2019.
He had wanted me to take a look at it. Yeah.
And
I don't know. Let me not specify a date. I don't know when the date was, but he had said, take a look at what this is.
now, you were ordered not to use monikers created at Flow, correct?
Correct.
And we know that the moniker Greatest Mind in Wrestling was created at Flow, correct?
Yeah. I mean, yeah.
And yet when Nick Velikat, the vice president of marketing at Rokfin, asked you, isn't there a problem with Rokfin using that moniker in its advertisement? You said, I don't give an F, right?
No, that was not in reference to that. That was in reference to the term crystal ball.
Let's put up exhibit 13, plaintiff's 13.
I could be misremembering, but I thought that was in terms of, in reference to the crystal ball.
Now, the crystal ball, well, Mr. Bouchron's getting that. The crystal ball is also a moniker and name that you used for your broadcast at FLOSPORTS, correct?
I wrote an article called Crystal Ball.
On a regular basis?
No. Where at Flow?
Yes.
One time.
You wrote an article called Crystal Ball. And how else did you use that moniker at Flow?
Never.
You're saying you only used Crystal Ball one time at Flow? That's
Yeah,
right.
about a week before I left. Or I don't even know if it was a week.
So you had just created that at Flow before you left.
Well, yes, but let me clarify. I didn't create it at Flow. There's lots of different sports. It's a general term for predictions.
You used the term crystal ball at Flow, and then you took it and used it at Rokfin, correct?
I used it at Rokfin one time.
Now, Eric, can you show us P13?
Well, before
believe he's
he puts that up, it's marked confidential, and apparently there's an objection to it. I'm looking at it on the box folder, so perhaps we could just talk about it without specifics and without sharing it on the screen until we've resolved the objection. What is the objection to? Well, first, let me start with why is 13 offered and relevant?
This is contempt of Your Honor's ruling, and when he was asked, and so this is an example of the literal contempt for your ruling.
All right, and what's the objection to 13?
Well, Your Honor, the document, I believe, is produced confidential by Rokfin, so I'll let them make that objection. I think it's not relevant. It's being taken out of context, and it's not, and so we would object on relevance.
Okay, well, the relevance objection is overruled. Is there another objection by either Rokfin or anyone else?
Yes, Your Honor, we object. A number of, on both sides, the internal deliberations have been designated confidential and AEO. We have pending a motion to declassify many of those that are not being heard today. I think they should all be heard at the same time in the same context.
Well, that's not possible given the fact that she's offered it as evidence in the contempt hearing. So let's talk specifically about this one. What specific objection is there to this document for purposes of this hearing? I mean, we can certainly limit the offer and limit its admissibility to this hearing if that solves some of the problem. I don't know that it might be offered in any other context for it to demonstrate anything else overall, but certainly we can limit its purpose and its admissibility for purposes of this hearing only, but I don't know if that solves the problem or not, because I don't know what the problem is with this specific document that's 2 pages.
And we have a protective order, so we should be able to admit documents, even if they are.
Let's let them articulate. I understand you want it in. I want to hear why they don't think it should come in. I've already overruled the relevance objection. I'm now trying to understand if there's some other objection other than the fact that it's marked confidential, which is
Your
not
Honor,
persuasive as it relates to the contempt motion. So is there another objection that we should entertain?
Your Honor, your suggestion that we admit it for this hearing only, I don't know that it needs to be put on the screen, since the court can look at it and the witness can look at it at this point in time until we resolve the much broader issue on many, many documents that are going to be in front of the court.
I don't need it to be displayed for purposes of looking at it because I have access to it. I don't know if Mr. Saylor does. And if he doesn't, then perhaps we could get his counsel to email it to him so that we don't have to show it on the screen, if that's a way to solve it.
That's
so
fine
it's
with me.
not displayed.
It's going to be an issue that comes up throughout all of these, because I think every single document Rokfin has designated as AEO or confidential, but that I will
Well,
represent. So,
I don't want to deal with them without some context. So I'm looking at this one. I've read this one. I appreciate the arguments here. The objections are overruled, but P13 is offered for the limited purpose here for this motion.
and I'm telling Mr. Bouchard not to put this on the screen. Don't put this on the screen. Okay. And I'm going to say the same thing about the next document that I pull up next. But let me ask you a couple questions about that, Mr. Saylor. Is it okay if I proceed, Judge?
Yes.
Okay. So, Mr. Saylor, the fact is, you know that it's not just, oh, no. Eric, don't do that. Eric, don't. Okay. Are we good, Mr. Bouchard? We're good. Being in different rooms is really difficult. So
Well, you should understand that there's a little bit of a delay in the audio. So it takes a second or two for people to hear what you've said after you've said it. And that might explain that, but it's okay. We'll work through it. You may proceed.
thank you. So, Mr. Saylor, the document, can you see the document?
I've reviewed the motion several times. Maybe if you tell me what it is, I might know what it is. I don't.
Well, when Mr. Velikat asked you about monikers.
Is it the F word one?
I'm sorry?
It's the F word one?
It's the F word one.
It's the F word one. Yeah, that was okay, I'm sorry, what's your question?
It was contemptuous of the court, right? You said, I don't give a F about what the court ruled, right?
No, ma'am.
And the fact is that you also have a
Your Honor, may I object? I object to her interrupting the witness. The witness was not done answering the question and was going to explain why it wasn't contemptuous of the court, which is.
He wasn't asked to explain. He was asked whether he did it or not. He said no. That's the responsive answer. What's the next question? You can ask him more questions when it's your turn to redirect, but he answered a yes or no question. No. Next question.
Yes, Your Honor.
Mr. Saylor, the greatest mind in wrestling, Rokfin also uses that to advertise you, correct?
I'm not sure exactly what they use to advertise. I haven't used that term. I called my show. That was the title of my show. And I obviously haven't used that since the temporary injunction went into place.
That are you testifying you have not used greatest mind in wrestling since the injunction went in place?
Yes.
Eric, I would ask that you pull those examples up.
I personally, no, I have not.
Sorry, I didn't hear the exhibit number you were asking about.
I will need to tell you which exhibit numbers that is. Mr. Bouchard, can you help me out with which exhibit numbers these are? They are in the, they're going to be tweets and advertisements as well as Rokfin advertisements.
Well, that might be the problem.
Hang on, Mr. Saylor. She's going to ask you a question in just a minute. Until then, just stand by, please.
Understood, Your Honor.
Hold on just a moment. One of the examples, I believe, will be P33. As well as Mr. Bouchard, as a number of examples from Mr. Saylor himself. And these are also at slide 52.
Your Honor, as to P33, that's been designated by Rokfin as attorney's eyes only. So obviously my client has never seen that in that configuration because it's got an attorney's eyes only designation. So we would object on the grounds it's unfair to examine a witness on a document they would have no access to.
Well, it's not clear to me that he didn't have access to it before the lawsuit. So let's get clear first on what it is the document is before it is displayed, since we now know there's an objection to it. So let's take it one step at a time. Ms. Burgess, are you intending to ask the witness about plaintiff's exhibit number 33?
I am, as well as the exhibits that make up slide 52, Eric, if you can help me with that.
I don't know about your slides, so let's refer to the exhibits for the purposes of the court reporter's record by plaintiff's exhibits or defendant's exhibits. And for the defendant's exhibits, we ought to designate them defendant Rokfin versus, and then separately defendant Saylor, because they're two different defendants here. So tell me first, Ms. Burgess, what, generally speaking, without divulging the confidential information, is plaintiff's 33?
It is the campaigns that Rokfin runs to advertise Willie Saylor. And not only do they reference FLOSPORTS, but they also specifically advertise him as the greatest mind in wrestling.
Your Honor, I would say a couple things. I don't believe that Mr. Saylor has ever seen this document or this compilation like this. I would note that as to relevance, there's nothing here other than the 1 April 2020 entry that has anything to do with 2020 after this court entered any injunction. So it's not his document. I don't think he's seen it because it's attorney's eyes only. And I think it's inappropriate to ask a witness a question about that when she can ask what she's trying to get at in other ways without having to go through this document. We would object on the fact that it's AEO and she hasn't established a predicate that he has any information or knowledge.
Your Honor, if I may, this is our marketing spreadsheet that we put together, and it's AEO in response to some questions they asked in this lawsuit. So it was created to give them information in this lawsuit. In addition, this is the first version of this, and it was replaced by a different document, which I'm sure FLOSPORTS knows, which is Rokfin 6073. So this is not something that was created contemporaneously at the time. It's something that Rokfin put together with no input from Mr. Saylor that he knows nothing about, that isn't even the current answer to the question that they asked.
When was the document created by Rokfin?
Ms. Kling-Sison probably knows the answer to that. I do not.
I do, Your Honor. That spreadsheet was created for a production on June 8th, 2020. And after the deposition of Rokfin's VP of Marketing, we, at FLOSPORTS' request, revised the spreadsheet to add more information. And that is in the record as the Defendant's Exhibit 13. It's also AEO, and Willie Saylor had no contribution in creating the document.
All right. Ms. Burgess, it may be relevant and it may be admissible against Rokfin, but as to your questions about Mr. Saylor, it's not clear that he's even seen it or had anything to do with the creation of it. So at least as to Mr. Saylor, it's not admitted.
Mr. Saylor, have you seen ads where Rokfin is advertising you on Facebook as the greatest mind in wrestling since the TI?
Mr. Saylor, you're on mute.
I don't recall. I have seen ads where they say greatest mind in wrestling. I don't recall what the dates were. I know, I'm very confident that the last time I personally used, not Rokfin, not Rokfin's marketing department. I'm very confident that the last time that I used the greatest mind in wrestling phrase was before the TI when I did my show. When the TI went into effect, I could no longer do my show. Therefore, I didn't use it. I can't speak on what ads were. I don't have anything to do with ads.
And Ms. Galaviz and Mr. Boucher, I need your help to show these and also Mr. Saylor's usage of it, please. Well, we're going to get those. Oh, here we go.
I need to know what exhibit number you're trying to share here before that happens, please. What exhibit number?
Eric,
Ms. Burgess, what's the exhibit number you're trying to display?
I'm
Yeah.
asking. Oh, go ahead, Mr. Boucher.
P14, Your Honor.
Is there any objection to 14?
We get it, we have to get it up here. Find it, Your Honor.
Your Honor, I don't know if I was on mute, but I meant to say, with regards to P14, we have no objection.
Vicky,
No objection, Your Honor.
14 is admitted.
Eric, go ahead. Mr. Boucher, go ahead, please. Okay, Mr. Saylor, is this a tweet that you sent out on March 29th, 2020?
Yeah, looks like it.
And you're using the greatest brain in wrestling?
I mean, it's an emoji.
That's the same emoji you used at FLOSPORTS.
A brain emoji. I'm not allowed to use the brain emoji. Is that what?
You
That's
used
not the question. Her question was whether or not you used this particular line with these emojis when you were at FLOSPORTS.
I use the phrase greatest mind in wrestling. I don't know if I used greatest brain emoji in wrestling emoji. I don't know if I've ever done that. I don't know.
in fact, you use the brain all around in a circle, correct? The brain emoji all around in a circle for you?
Some guy that has a apparel business made up a t-shirt. He saw it on Twitter and he thought it'd be funny and he made up a t-shirt. I mean, it was a internet meme thing. I mean, I didn't really have anything to do with it.
But Rokfin advertises you with that image, correct?
I think they did when I had a show that was titled that. I don't know if they did since. Like I said, I don't run ads. I don't know what ads they put out. And,
Now,
I don't know the dates that they put it out.
yeah, in Exhibit P13, when you're talking to Nick Velikat, the Vice President of Marketing at Rokfin, sorry, I dropped my bike. In P13, when you're talking to the Vice President of Rokfin for Marketing, who previously worked at FLOSPORTS, correct? Nick Velikat previously worked at FLOSPORTS?
That's right.
Nick Velikat previously worked at FLOSPORTS?
That's right.
And when Nick Velikat is placing ads to advertise you and he's using Rokfin money to do that, right?
I don't know. I would assume.
And when he's doing that, he's consulting you about your usage of monikers, correct?
I assume that you're talking about that particular direct message thread.
But he consulted you other times about your usage as well, correct?
About my usage of monikers? He might, not that I recall.
And the fact is only 6 people work for Rokfin, right?
I don't know how many people they employ.
You were one of their employees for a few days, correct?
Yeah, for a few days. 9 months ago. For a few days, 9 months ago.
And you previously worked with Nick Velikat at FLOSPORTS, correct?
Yeah.
And when he coordinated with you about the monikers, your response was an expletive, correct?
My response was,
I'm going to object. That's misleading. It misstates the record. It wasn't about monikers in general. There was a very specific thread that she's referring to. So I object to it as being misleading.
Perhaps you could clarify your question, Ms. Burgess, to be clear.
The you used a specific expletive to say how you felt about prohibitions on use of monikers.
No,
Your Honor, go ahead. I'll withdraw the objection. Go ahead, Mr. Saylor.
I didn't use a particular expletive in my reaction to a TI or in reaction to the use of monikers. I said what I said as a reaction to, frankly, your consistent nitpicking, overreaching interpretation of what you think Judge Livingston's orders are, which is not what I interpret it to be. And I mean, frankly, I think your interpretation of what her order is overbearing and nitpicky.
I'm not even going to object to that. That's, Judge Livingston also ordered you not to compete, correct?
Yeah.
Okay, and July 25th, 2020 was one of the first wrestling competitions since COVID, correct?
One of the first. Yeah, there were others.
You understand that it took a great deal of investment to put on a wrestling tournament in the midst of COVID crisis.
I don't know. I don't know what that has to do with anything either.
And you tweeted out that you were not going to write about that out of principle, correct?
Somebody tweeted at me asking if I was going to write an article previewing it, and I said no out of principle.
And you, and that's exhibit P4, move for admission of exhibit P4. It's a tweet, so I doubt it's confidential.
There was a lot of context around that particular issue as well.
Just one
Objection
second.
to petitioners 4.
Your Honor, I'm looking for it. I don't think there is any objection. Let me check. I haven't been able to find it because, again, they're not in order or weren't provided until shortly. But yes, no objection to P4. No objection to P4.
Hey, Your Honor, I'm looking for it. Hold on. No objection.
4 is admitted.
Are you keeping track of what's been admitted? Great.
And then you joked about you cutting the cord when there was a glitch at that event, correct?
Yeah, I would like to talk about the context, though. I don't know if I'm allowed to.
Mr. Saylor, remember a couple of things. One is there going to be some other lawyers, including your own lawyer, who's going to get to ask you some questions, and they may want to ask some follow-up. But right now, I just need you to answer the specific question Ms. Burgess has asked. And then later, when the other lawyers have an opportunity to ask questions, you can answer just those questions, okay? Ms. Burgess, what's your question?
Yes, and then you joked about you cutting the cord of flow when there was a glitch, correct? And
Yep. Yes, that was a joke. Obviously, I did not cause the stream to crash.
please, I move for the admission of P5, another tweet.
No objection, Your Honor.
Well, I have to look at it. No objection.
5 is admitted.
And going back to testimony that you gave to this court in December for the temporary injunction, you want people to subscribe and pay money to Rokfin to subscribe to you, just like you did when you were at Flow, correct?
Well, of course. I mean, if you have a store, you want people to purchase stuff at your store.
Right, and your store, people go through the front door, they go through Rokfin. They can't subscribe without going through Rokfin, correct?
I liken it to Twitter. I mean, if there's a person on Twitter, you can't get to my Twitter handle without going to Twitter. If Matt Scouts is my company, you can't get to Matt Scouts without going to Rokfin, no.
And is Matt Scouts an entity?
Not legally.
And the only way you get paid is Rokfin gets paid and then pays you a percentage, correct?
Yes.
And they don't just pay you a percentage for people who go to your site one time. They pay you a percentage
for everyone who subscribes because of your tweets or your actions, correct?
Well, I think I need to clarify, because in your opening, you said something to the effect that when I tweeted, I was driving people to Rokfin, but there were tweets that had no links to Rokfin whatsoever. So it's not that I get paid upon, there's an algorithm that I am, it's math and it's well beyond my comprehension. But
No, every time someone goes and subscribes to Rokfin because of your tweets or otherwise, you get a percentage of their monthly amount, right?
that's how the system works, except one, I can't articulate it because I don't even know what the algorithm is, number one. And number two, there's a significant difference in the slide that you put up in your opening when you had subscribers. That's not accurate.
Mr. Saylor, that's not the question before you. The question before you, which I'll again ask you to just answer that question before you, has to do with your compensation. Specifically, are you compensated when, in some percentage or other, when new customers come to your new employer? That's the question.
Yes, Your Honor.
And what's the answer to that?
Yes, I mean, you get a subscriber and you get money.
And that money continues for as long as the subscriber keeps paying his or her monthly amount to Rokfin, correct?
Correct.
Now, when this picture that we're looking at in P5, this is you joking about cutting the cord at FLOSPORTS, right?
Yeah, that was posted when the stream crashed.
And it's July 25th, 2020, the date of the FLOSPORTS event, correct?
Yes, there was a flood of people saying, Willie, what did you do? And I joked and I said it wasn't me.
And let's go to P6. These are articles.
No objection.
Do I need to wait for?
We need to see if Ms. Dickey has an objection. I assume she's looking for it.
I'm looking for it and I'll let you know if I have an objection. No objection.
6 is admitted.
And you actually wrote 3 lengthy articles about FLOSPORTS event, correct?
Yes, I did.
And those were, Rokfin published those articles.
Well, Rokfin doesn't publish anything. The creators do. I mean, you don't have to seek permission. It's like Twitter, right? I can publish whatever I want on there.
You can publish whatever you want, but isn't it true that Nick Velikat and even Martin Floreani curate it and edit it sometimes?
I don't know of an instance where they manipulated anything on my channel.
Sometimes you submit your articles to them first and they help you edit them.
Absolutely not. That's never happened once.
Okay, we'll have to add to box to show that. Did you were at Nick Velikat's deposition, correct?
No.
You didn't participate in that.
I mean, let me clarify. There might have been an occasion where I said to Nick, hey, what do you think about this article? But it is not, and I don't even think that happened, but if it did, it's a very rare occasion. I don't have to get approval to publish anything.
But both you and Rokfin are under an injunction that keeps you from competing against FLOSPORTS other than certain carve-outs, correct?
Yeah, I don't know how this would go against the injunction.
Now, during that tournament, you found a domestic dispute that involved a FLOSPORTS employee, correct?
I didn't, no.
Well, you retweeted about it, didn't you? You republished it.
Yes, somebody tweeted it.
And then you retweeted it.
Yes.
And let's go to P7.
Any objection to 7?
Let me find it, Judge.
Okay.
I don't really know why these things aren't in any kind of order, but that's the way Box seems to do it.
Well, in my experience, and as I'm looking at it on Box as well, there are 3 pages, and so you might want to start on the last page. Sometimes when they're uploaded 1, 2, 3, they end up on the last page of Box, not the first page of Box. So you might just try that. That sometimes works for me. Don't know if it'll work for you, but it does sometimes work for me.
And Your Honor, as to P7, as to P7, Your Honor, for the purposes of this hearing, no objection. The limited proffer in connection with the issues in this hearing.
Joining that, Your Honor.
7 is admitted for this hearing.
So here we go. Now, you probably know Mr. Helton, right? You probably worked with him, Mr. Saylor?
I do.
And you retweeted that perhaps the glitch occurred because he got involved in a domestic dispute, correct?
No, the person in question said, "Is this why the flow feed crashed?" I responded, "Makes sense. Makes sense to me that if the head of production is not there at a time when the feed crashed, that would be logical."
Do you know when this instance actually occurred?
No,
Do you realize it occurred in 2019?
I did not know that.
And I believe, Eric, I believe this is the next page of P7. Also, do you see that this tweet that you republished says after assaulting his own wife at a company party at Flow HQ, correct?
Yeah, it says, that's what it says.
Do you know that's totally false? He didn't do anything at a party at Flow HQ?
No,
Nothing.
I didn't know that.
Okay, yet you tweeted it out so people would have a dark feeling about FLOSPORTS and decide to go to Rokfin.
I responded to a tweet saying that makes sense. That's what happened.
And it went to all your Twitter followers, right?
Yeah.
How many people saw that through your tweet?
It looks like 60 maybe. I don't know.
How many people do you have as Twitter followers?
24,348.
Okay, and so any of those would have seen this on your Twitter feed, correct? They could have.
Every one of them could have saw it, yeah.
Now, let's go to, are you going to retract that since it's false and it is an attack on both Flow and its employees? It's a completely false attack to try to drive subscribers to Rokfin.
Your Honor, I'm going to object to that as an inappropriate question. There is a mechanism to retract what people believe is libelous or defamatory, and nobody has availed themselves of that. And if they do, we will respond accordingly.
Objection is overruled. You can answer that question. Do you have a plan to retract or the statement or not?
I didn't cross my mind. I didn't know that it didn't happen at a party. I didn't know that it happened in 2019. So, I mean, I don't.
Yeah, I think the question is, now that you know that, do you have plans to retract it?
If Your Honor would like me to, I will.
I'm not ordering it. No one's asked me to do that. The question is about your intent. You either have an intent to do so or you don't. Which is it?
I mean, sure, I'll take it down. I mean, it's buried. It's a month ago. Nobody's ever going to see it again. But yeah, sure.
Well, and let's go to Exhibit 35. P35. I'm sorry, P35.
Any objection to Exhibit 35?
Yes, Your Honor. I think P35, as I see it here, the way it's been loaded up on Box, does not show that Mr. Saylor was copied on it. He's not an author. He doesn't look like a recipient. So I don't know. He can authenticate or be questioned about it. So I'd object on that ground.
It's a tweet.
Same objection.
We can see from what's on the screen at P7 that these guys follow one another.
Going in the objection, Your Honor, it doesn't have Mr. Saylor anywhere on it.
It references him.
Mr. Saylor, does Mr. Saylor have access to it? Is there any suggestion, Ms. Burgess, that it's authored by Mr. Saylor or that he participated in the conversation?
That's what my question is.
Well, I meant from the document on its face. Whether somebody else is talking about him or not is not the issue, right? That would just be a bunch of hearsay. So we're not asking that. I'm asking whether or not you're making a suggestion that in some way Mr. Saylor had something to do with it. Is that your contention is what I'm asking?
I am. It says that they have a common goal to destroy flow.
Okay, so let's
See that.
let me find it. I'm having trouble finding it as well at the moment. So give me just a minute. My box folder has gone somewhere else. I don't know what the story is there. Give me just a minute.
Mr. Saylor, this is the court reporter. If you could not speak when the attorneys and the judge are talking to each other, that would help, because I did not hear what you said when you interrupted the judge just then. So just try not to talk unless you're asked a question, please.
I apologize.
Okay, and so what's the objection to 35?
Your Honor, to the extent it's being offered into evidence, we would object to it on the grounds of hearsay.
Ms. Burgess, you want to respond to that objection? It does seem to be clearly a hearsay statement, more than one statement. What's your response to that?
I'd like to question the witness about his work with Mr. Mineo on this common goal.
You can ask Mr. Saylor questions. I don't know that that gets the document admitted, so I'll sustain the hearsay objection.
And may I reapply for that if we get further down the road, Judge, if I lay more?
Absolutely.
Okay, thank you. So can you see the document, Mr. Saylor?
No, it's not on the screen
Your
now.
Honor, same objection. I'd object to her asking.
Mr. Sotero, thank you. Just if you just say objection, then if I need more information, I'll invite that. But in this environment, because of the delay, it would be helpful just to state the word objection and let me take it from there. Ms. Burgess, I don't intend for you to ask him any questions about it because it's not yet been admitted. You can certainly ask him about his own motivation.
Thank you. Mr. Saylor, we saw from the previous exhibit that you and Mr. Mineo follow each other on Twitter. Is that a fact?
Yes, ma'am. He was actually kind of a thorn in the side of Flo wrestling for a long time. That's how the actual relationship started.
Well, and yet now you have a common goal to take out Flo.
I didn't say that.
Have you ever talked to him about FLOSPORTS?
I don't recall. I've never met him in person. I've never said my goal is to take down Flo. It's not possible to take down Flo.
I'm sorry. You talked to Mr. Mineo about a common goal to hurt FLOSPORTS, correct?
No, I just said that didn't happen. I don't know what.
You've never talked to him about that. You've never had any communications about it.
I've talked about Flo with him. Yes. Not about a common goal to take down Flo. No.
You retweeted his post about his inaccurate post about FLOSPORTS employee, correct?
Yeah.
Well, you've already asked him that question. He answered that he did, if that's a reference to the mugshot. It's not clear to me if you're asking him if he retweeted this comment.
Mr. Saylor, how do you correspond with Mr. Mineo?
I talked to him on the phone a couple of times.
Okay, and you talked to him about FLOSPORTS.
I talked to him about wrestling. FLOSPORTS certainly comes up, when they didn't invite the girls to the to your event, your big event, and when the stream crashed, I think we discussed things like that.
Now, you know that the women wrestlers were invited, correct? They were unhappy with the compensation.
No, I don't know the details. The only thing I know is that there were no women on the card.
So the fact is that you talked to Mr. Mineo about FLOSPORTS between the time of the temporary injunction and his after the temporary injunction, correct?
Yeah, I mean, along the lines of, what do you think about this card? And can you believe there's no women on it? And can you believe the stream crashed? Things like that.
Now, let's look at Exhibit 40 or 11. I'm sorry, P11.
Your Honor, this is also hearsay. Objection.
What in the objection?
This is not for the truth of the matter asserted, but rather to show people saying that they are going to follow Mr. Saylor's lead while he's competing and leave FLOSPORTS and go his direction.
Your Honor, if it's not offered for the truth, I don't think it's relevant.
You'll both just give me an opportunity to review the document. That would be helpful. The hearsay objection is sustained.
Mr. Saylor, do you know that people are taking your lead and following you over to Rokfin from FLOSPORTS?
No, I don't know that to be true. And I don't think that is true because now I don't have any knowledge of how many subscribers Flo added or lost. I do know how many subscribers I have gained, which is minimal. And I would also say that at no point in time, you said in your opening that I have encouraged people on Twitter to leave Flo and go to Rokfin. And I would ask you to find any evidence of that whatsoever, because that's never happened. In fact, I wrote an article when right before your event, I wrote an article and said, don't cancel Flo. I'm not going to cancel Flo. I'm not canceling. I'm not doing away with my subscription.
How much does Rokfin cost every month?
$10.
And how much does it flows on an annual basis, right?
150, I think, last time I knew.
So roughly the same monthly, right?
I would, yeah.
And people have to pay for it to get that to get to the behind the paywall, correct?
Yes.
And both are offering wrestling content behind the paywall, right?
Yes.
How many active subscribers do you have?
Your Honor, I would object to relevance.
Yeah, I don't know what.
Well, I'm confused about the you, Mr. Saylor, personally, Rokfin. Who are you asking the question about?
Well, when people join Rokfin, they do it through someone, and so that's how Mr. Saylor gets paid, is by how many
understand
people?
it's a percentage, but I don't understand your question. What is your question? How many subscribers does Rokfin have? How
Two.
many subscribers of Rokfin's is Mr. Saylor being paid for? I just don't understand
Exactly.
that. What? But yeah, but that's multiple questions. Which one are you asking?
The last one, how many Rokfin subscribers is Mr. Saylor being paid for?
Your Honor, objection relevance to this hearing.
Overruled. Go ahead. You can answer that question.
723.
And you joined Rokfin when?
November 6th.
I don't understand the objection. I didn't hear you.
I don't either. I withdraw it.
November 6th, I think, was the first day.
Okay, let's look at Exhibit 40. P40. It's a publicly facing part of Rokfin.
Your Honor, while we're looking for that, it's approaching noon. Are we quitting right at noon? And can we
I
have,
want to at least finish this witness.
well, it's going to be her direct of him, not her prop.
Yeah, I understand.
Okay, well, I would appreciate it.
We will take a break. I've got to give my staff a break for lunch and so forth. But for now, let's just keep going. I'll let you know when to stop.
Okay.
Did we get to P40?
I think they're looking to see if they have any objection to 40.
Your Honor, objection relevance.
I don't know what
It may
40 is.
also be, it may also become,
Why is 40 being offered? What's the purpose of 40?
It shows the number of subscribers on Rokfin. Showed that Mr. Saylor's 700 subscribers is actually a really significant number of amount of what's going on at Rokfin.
The relevance objection is overruled.
And it's a publicly facing document. We got it off the internet.
Any other objection to 40?
no, Your Honor.
40 is admitted.
Okay, so the total number of subscribers on Rokfin is 3,700, Mr. Saylor?
I haven't looked. That sounds about right. Last time I looked.
Okay, so that means that, you know, your 700 is what, 1/4 of that, a little bit, or I guess 20% of that?
Yeah, I would. Sounds about right.
Okay, and in fact, their subscribers spiked when you joined them back in November, correct?
Yes.
And did you get about 300 subscribers out of FLOSPORTS event in July?
Did I get 300 subscribers? Absolutely not. In July, no.
You didn't add 300. How many did you add at the end of July or August?
I don't know, but I didn't go from 400 to 700 in July. Can I clarify, Mrs. Burgess?
Sure.
So there's subscribers and there's followers. There's people like you can go on to Rokfin and follow a channel.
I understand, but you only get paid on subscribers. How many subscribers did you get after July? Have you gotten since July 25th, 2020?
I don't know. I mean,
let's
July 25th, I would say about 15.
Now, you understand that from the temporary injunction, the only carve outs are for rankings and future sporting events, correct?
No, written editorial.
About future sporting events, correct? Okay, and yet you went back and reviewed a 2013 article recently on Rokfin, correct?
Well, I didn't review it as much as their careers came to a close. So I evaluated their careers because they all graduated. The last of them graduated in March, or their careers came to a close in March, approximately April.
I move for admission of P18.
Uh-oh. Sorry,
I don't know what that means.
Well, I just exited the box.
Yeah, that happened to me earlier because it's difficult, a little bit clunky to go from one exhibit to the other without going back to the list, which requires several clicks. We're going to try to, or I'm going to try to work on that with my IT department and see if that is something we could work with Box on to improve for purposes of hearings. But in any event,
What
let's see if we
exhibit,
can
what
find
exhibit number are we in? I don't even know now. What number?
18.
18.
It's an article from Rokfin.
Sorry, I'm in Descendants 18.
I don't have an objection. I disagree with that characterization. But it's an article of Mr. Saylor's, I believe, that was posted on Rokfin.
Yeah.
Okay, well, I can't find it, but if you don't have an objection, I don't have an objection.
Well, let me describe for you that it is, it appears to be a Rokfin document that relates to a 2013 article entitled Best Values, Best Busts, BUSTS, with a photograph of wrestler type people and an article.
I just found it, Your Honor.
Okay.
My technology skills are not as great as they should be.
It's a learning curve for us all. So, any objection to 18?
No objection.
18 is admitted.
Thank you. And in 2013, you worked for FLOSPORTS, correct?
That's right.
And you posted this on Rokfin.
Yes.
Okay, now it's true, isn't it, that you are now there's no carve out in the injunction, is there, for fantasy wrestling?
Object to the form of the question.
I think it's confusing to talk about a carve out in the way that you've suggested it because it may assume a fact that's not in evidence. Perhaps you could rephrase your question more clearly.
Thank you, Judge. Is the term fantasy wrestling in the temporary injunction?
No, but the term future wrestling event is, and that's what fantasy's all based on.
And you did fantasy wrestling at FLOSPORTS, correct?
No, I wrote two articles. I wrote two articles in 8 years about fantasy when I was at Flow Wrestling.
Let's move to Exhibit P17. I move to P17.
Excuse me.
No objection, Your Honor.
No objection, Your Honor.
17 is admitted.
And this is fantasy wrestling you're currently doing during the COVID crisis on Rokfin, correct?
Yeah, that's an article about fantasy prospects for next season.
Okay, what event is it about?
It's about the next college wrestling season.
The whole season, right? Not a particular future wrestling event, right?
Yeah, right, about the season.
Now, rankings is specifically mentioned in the temporary injunction, correct?
Yes.
And you're allowed to do that, right?
Yes.
But not so, fantasy wrestling is not mentioned.
No, future wrestling events are.
Let's go to P41 or I think it's P25. I'm sorry, P25, which is also Rokfin 41. I think, based on my notes.
No objection.
P25, sorry. I said that's a whole different one.
The objection, Ms. Dickey?
Yeah, I can't find it. Ah, there it is.
I'm sorry, I didn't hear the last part of what you said.
Oh, there it is. I'm looking at it. No objection, Your Honor.
25 is admitted.
In addition to fantasy wrestling, you're also doing recruiting, right? You're writing about recruiting, not about future events, but recruiting, not about ranking, but recruiting.
It's wrestling news.
Okay, so you think you can write about any wrestling news under the judge's order?
Yeah, written editorial comments, yes.
And it doesn't have to be limited to a future wrestling event,
No,
as it is worded in the order.
That's the genesis of that conversation with Nick Villicat. I was not talking about Judge Livingston's orders. I was talking about your interpretation of it, because when Judge Livingston said future wrestling events, your interpretation is clearly that he can't write about something that happened yesterday, right? I mean, no journalist, if there's a football game that just happens right now, a journalist has to write about something that happened 5 minutes ago, right? So that was your interpretation.
Where's the wrestling event that this that P25 talks about?
There again, you're talking about events. You're talking about events as if it's a competition. My interpretation of Judge Livingston's TI is that future events, future things, not retroactive before the injunction went into place, but future, looking forward, things that happen from now going forward, and events, things that take place in wrestling news and community. It doesn't have to be a competition. I mean, obviously Judge Livingston can clarify, but that's my interpretation of it.
You thought you could write about anything in the entire wrestling world as long as it might be about the future.
I thought that I can write about wrestling news. Yes, if Brian Soldano, who's a top 20 recruit in the class of 2021, if he commits to Rutgers, it's a big deal. And written editorial comments, I should be able to say, hey, Rutgers got this guy, and here's a good fit for them, and this is why.
I'd like to next put up the injunction itself. Mr. Boucheron, can you put up in particular paragraphs 8, 9, and 10 of that?
Ms. Burgess, I suspect you may read in a second. When you do so, please don't read too fast.
Thank you. I'm terrible about that. It's a bad habit I think we all have. But while Mr. Boucheron is pulling that up, Mr. Saylor, this was just posted on July 14th, 2020, correct?
This article here?
Yes.
Yeah. Yep.
And on Rokfin, correct?
On Mad Scouts, yeah.
And well, I would view it through my Rokfin subscription, right?
Yes.
And my money would go to Rokfin, and then you'd get a percentage of it, right?
Yes.
And the truth is, you also have been posting stories about recruiting throughout this past weekend, right?
Of course, I post recruiting stuff all year long. That's like my niche.
Let's look at paragraphs 8, 9, and 10 of the injunction here. So, and I'm going to read slow because the court reporter just specifically asked me to. Okay, Mr. Saylor, can you see this?
Mm-hmm.
Now, I call these the carve-outs, the things that the court allowed you to do in terms of competition.
Yeah.
It says, defendant Saylor is not prohibited by this injunction from writing, producing, or publishing written editorial comments about future sporting events, correct?
Mm-hmm. Yes.
It doesn't say in any of these, it doesn't say that you can cover the entire industry of wrestling, does it?
I think it does. Written editorial, written editorial? Yes, that's comments on what's going on in the wrestling world.
Now, when you say about future sporting events, There's no particular event that you're talking about when you're talking about these when you're writing these recruiting articles, correct?
No, that's, again, we have a conflict on the construction of the word events. Your interpretation of the word events in this dialogue is that it has to be a competition. My concept of the word events is goings on.
And it also specifically allows you to talk about rankings of athletes, correct?
Mm-hmm. Yes. No.
Yeah, it says nothing about recruitment.
No, it doesn't say anything about news either. It doesn't say anything about recaps. I mean, they all fall under written editorial comments about wrestling events.
Now, we also know that you admitted during the temporary injunction that you have a non-compete and you can't do live events, correct?
That's correct.
Yet you took some live events you've suggested live events to Rokfin over time, correct?
I've talked about live events, yes.
And you know that Judge Livingston's ruling says that you can't have any videos, live streaming, or broadcasting, correct?
I have not.
But all your videos are still up on Rokfin, right?
They were all videos, and I'll say this, they were all videos from before the injunction went into place. And if Judge Livingston wants me to take them down, I'm fine with that. I'm fine with complying in any way.
If I buy a subscription to Rokfin through Willie Saylor or Matt Scout's your trade name, I can access lots of videos, correct?
No, not lots of video. I mean, I'd imagine there's less than 24, the most recent of which is around December of last year. I haven't posted a video in 2020.
Your videos are still posted though. I can see them if I go to Rokfin, correct? If I have a subscription?
Yeah, from 9 months ago.
Even if I'm a new subscriber, I can see technique videos on Matt Scouts on Rokfin, correct?
That's right.
Even if I just subscribe today, I can see videos of Willie Saylor.
Right.
And and I moved for admission to P19. Actually, let's do 19 and 20 at the same time.
And what is P19 and 20? I'm going to pull them up on Box, but if you can tell me ahead of time, it may make it easier.
Sure. P19 are videos on Rokfin, and P20 is the discussion of working with the Oklahoma group about a live event.
For purposes of this hearing, I don't have an objection to either 19 or 20.
Going.
(19 and 20) are admitted for this hearing.
Now, you are prohibited from using, by this injunction, you're prohibited from using or disclosing or using Flo's business information, correct?
Yes.
And yet you're on chapter 5 of your book about FLOSPORTS.
I didn't disclose anything.
Let's pull up, I move for admission of a tweet that is both these exhibits, P36 and P21.
No objection to 21.
No objection to 21.
21 is admitted.
Haven't found 36.
I think 26 is on page 2, Martha, if that helps.
36 that she's offered.
Oh, I'm sorry. Thank you, Your Honor. I'm trying to find it.
going to object to 36 on relevance.
What's the purpose of 36?
It explains that he's on chapter 5 of this book that we're looking at right now. It's a tweet about the same issue.
What difference does it make is the question. Why is the fact that he's writing a book in the future that has yet to be published relevant to whether or not he's violated the temporary injunction?
The temporary injunction includes using, disclosing. It's not just disclosing. It includes using. And he admits that he's on chapter 5 of this book, writing a book about our confidential information, which is actually under his agreement is tied up not for a temporary period, but rather he has a confidentiality agreement. He cannot write a book about this.
Excuse me, is the chapter included, or is he just saying I'm writing a book and I'm on chapter 5?
He just says I'm on chapter 5.
The relevance objection to 36 is sustained, 36 is not admitted, 21 is admitted.
And Judge, I would ask that, well, I'll just ask the questions around.
The book that's violative, we'll deal with it when he does so, but so far he hasn't published anything. Not a book.
Right. Well, there's use is also prohibited by the TI, not just.
Right, but he's not published anything in which it's demonstrated that he's used it. So it's premature. It's not ripe yet. Let's move on.
So, and may I ask a question around that issue though, without the.
Sure.
So it's true, Mr. Saylor, that you are writing a book about FLOSPORTS, correct?
Crossed my mind.
And well, I mean, it's not just crossed your mind. You're actively told the Twitterverse that you're on chapter 5, right?
I think I'm on chapter 7 now.
Okay. Do you talk about people from FLOSPORTS in this book?
Objection, Your Honor. This is completely irrelevant about something that hasn't been published, isn't in final form. I don't even understand where we're going with this. Relevant.
Relevance objection is sustained. Let's move on.
Let's go to Plaintiff's Exhibit 2.
I object to number 2. It's confidential. The date is November 2019, so I believe it is irrelevant.
Joining the objection.
What's the relevance of 2? What is 2 and what's is generally describe it for me, please have some context. And why would it be relevant?
It's just an example. Mr. Saylor previously denied that Rokfin edited content that went on his site, and it's an example of not only that, but Rokfin gathering quotes for him, etc.
From before the injunction was issued?
It is from before. It's right. It just shows.
The objection is sustained. 2 is not admitted.
Let's go to, I believe, Mr. Boucheron has added something to the box, and it would be 47 P47.
So I object if this has just been added while we've been at this hearing.
It has, because we did not expect him to deny the fact that he's using Greatest Mind in Wrestling and that Rokfin is using it to advertise him with the brain. We have, actually, I think it's P48 is the redacted version that defense counsel agreed would not be, we'd be able to use without the designation.
Your Honor, I'm going to object. If we're going to rewrite the rules for how we do these hearings, then we need to know that. We were very scrupulous about getting our exhibit list, our witness list, and our exhibits to Miss Burgess yesterday by 3 o'clock. And then she posts them in the middle of the night and gives them this morning, and then she starts coming up with other stuff. If that's the way we're going to do it, we need to know, because we will do it that way too.
So
when you're cross-examining a witness.
Excuse me, there's 2 issues here. One has to do with uploading documents that you know you're going to use. The other issue has to do with impeachment. What she is telling me is that this is in the nature of impeachment. So she could not necessarily have anticipated that he was going to make a statement which she believes she can impeach him with a different document that she did not intend to use. The rules don't really cover impeachment as such, not directly. And so I don't think it's fair to suggest that Ms. Burgess is doing something inappropriate or violative of the rules if in fact it's simply in the nature of impeachment. I will tell you that courts have gone a couple of ways. Some will allow what we might think of as an ambush in this context of impeachment because it wasn't uploaded first. Other courts have said, you know, if you could have been surprised, ambushed, if you will, in court with an impeachable document, why not let that same procedure occur in this remote environment? I've not really made a decision about that as a rule. I have handled that on a case-by-case basis. Some things I think even if you use them for impeachment might have been anticipated and should have been uploaded ahead of time. It's possible that I might encounter a situation in which it's true impeachment, not anticipated, that someone would make a statement contrary to something that is pretty clearly impeachable, and then I might make a different ruling about that. So I don't have a hard and fast rule on it. We do have the benefit of coming back next week, since clearly you won't be finished today. So let's hold off on 47 until we get to the hearing next week. That will give everybody ample opportunity to review it, and it won't change the outcome since we're not going to finish anyway. Let's move on.
With that, I'd like to just take our break now, if that's okay, and do, is there a lunch break right now?
Well, I didn't call for one because I'm trying to get us a little further along. So is there something else you can discuss with this witness, or are you at the end of your testimony with him?
I'm really at the end of my testimony. I wanted to look over my notes real quickly before I passed him, but.
Well, let's give you an opportunity to do that. I very much want to finish up as much of Mr. Saylor's direct examination as possible before we start talking scheduling. So if you're about done, that'd be great. But take a minute to look at your notes, and then let's see if.
I take a quick comfort break for. Can we have 10 again?
Sure.
Super. And then I'll probably have 5 minutes after that.
All right, well, let's take a 10-minute break and we'll resume in 10 minutes. I will go into chambers and you may stop sharing your screen, Mr. Butcheron, and we'll be back. If you wish to stop your video, you may do so. Some of you got lost the last time we took a break, so my suggestion is that you do not leave the meeting. Simply turn off your microphone and turn off your video, but do not leave the meeting because it took us an extra 5 or 10 minutes to get you back onto this meeting after the first break. So don't leave the meeting, just turn off your video and your audio. We'll be in recess for 10 minutes.
All righty, if everyone will make their way back into the gallery, I'll go get the court. So, court reporter, are you ready?
I'm here, Mary Jane. Go ahead.
All right.
All right, let's see if we can't finish this. Thank you, Ms. Lawson. Let's see if we can't finish up Mr. Saylor's direct at least.
Thank you, Judge. I'm going to go first to Exhibit P15, a tweet.
No objection, Your Honor, for purposes of this hearing.
No objection, Your Honor.
15 is admitted.
Can you pull that up, Mr. Bouchon? Okay, so this, Mr. Saylor, this is on July 29th, right? Oh, you're on mute.
Sorry, yes, that was July 29th.
Okay, and Julia Salata said everyone would have just listened to the greatest mind in women's wrestling, me, they would have known I called it from a mile away, correct?
Correct.
And you said, when I ran the ship at Flow, I tried to hire Julia like 452 times. She's stealing my moniker, but she ain't wrong, right?
Yeah, that was my mistake. I should have said was.
And then you put an ad for Flow Legal One. Can I get a ruling? It's a parody site. Maybe you set it up.
No, I think not.
Who set it up?
I don't know.
You have no idea.
No.
It's about your case.
You should take a look at Twitter right now and see what's happening.
I don't even have Twitter, so it's not going to happen. But so you called Greatest Mind in Wrestling your moniker, correct?
Correct. That was an error on my part. I should have said was.
Would you, Mr. Bouchon, let's go to P1, which is just the non-compete itself. This is your non-competition. Oh, I'm sorry. We should, Eric, we should wait to get objections to that.
Your Honor, my only objection to the way the plaintiff submitted it is not P1, the document itself, but there's an attachment, which is a demonstrative, which they can use for demonstrative, but shouldn't be admitted into evidence. That's my only objection.
That's fine with us.
So can we have the understanding then that petitioner's exhibit 1 consists only of the non-compete agreement? Is that what it is?
Yes, Your Honor, that's fine.
All right, P1 is admitted.
And just for the record, the demonstrative just breaks down, it's the slide that I showed that breaks down the non-compete. But let's just look at P1 itself, Eric. And you don't deny that you have a non-compete, Mr. Saylor, and you're not supposed to be competing with FLOSPORTS during the period of it, correct?
I'm going to object to the extent that calls for a legal conclusion, Your Honor. There's been considerable proceedings. Your Honor's entered an injunction. I don't think it's an appropriate question for this witness.
I'm just asking about the terms of his contract.
Well, I don't think she's asking him anything that he can't understand as a lay person and not make a legal conclusion. So I'll overrule that objection.
I have a non-compete for 1 year.
And in addition to non-compete, you also agreed not to solicit customers, correct?
Yeah, that's another thing in your opening that you
Mr.
suggest.
Saylor, please remember what we discussed earlier. You're just answering only the questions that she's asking, and other lawyers can ask follow-up questions if necessary, but you're not going to respond to her opening statement, okay? Just answer her questions. Ms. Burgess, what's your next question?
Isn't it true that you had an agreement not to solicit customers?
Yes, ma'am.
Okay, and in particular, you today you think that the injunction allows you to write about absolutely anything except for absolutely anything in the wrestling world, right? There's no injunction about your writing, right?
I believe in the terms of the injunction verbatim where it says I can write written editorial commentary about future sporting events. And to me, that includes news.
So you've decided that there are no limits on your writing, and that's how you proceeded.
No limit. I didn't say no limits.
Now, let's look at 3.2 of your agreement. Could you read the first sentence into the record for us?
I agree that the term of the
Oh, wait, sorry. You're going to have to go really slow because the court reporter is typing.
So let's do the court reporter and me a favor. It's in evidence. I can read it for myself. If you wish to ask him a question about it, you may, but it's just not necessary for anyone to read to me.
Got it.
What's your question to him about it?
You understand, Mr. Saylor, that although you had a 1-year non-compete, and here at the bottom of this paragraph, you acknowledged that the time, geography, and types of limitations on your activities were reasonable, right?
That's right.
And you also agreed that the the non-competition and non-solicitation provisions in this paragraph would be extended for any time in which you were in violation of this agreement, right?
Yes, I do know.
And it doesn't say any time you were in violation of your interpretation of a temporary injunction, does it?
No, it does not.
With that, Judge, I will pass for now, saving the exhibits that were added later so that I could come back and include that in direct later.
All right, so it's 12:35 and my staff and I have another hearing this afternoon, and so we won't be able to go, not to mention it's only a 3-hour docket and you've expended that. So we will break now. I'm not available next Tuesday morning, but I am available next Tuesday afternoon. Let me confirm that accuracy of this.
And Your Honor, while you
Everybody else available that day? I believe the date is September 1.
I can't believe it's September, but it does look like I'm available.
Your Honor, it's a problem for me. I mean, of course, if Your Honor orders something, I'm going to do whatever. But number one, I'm going to be with my child up to college and dealing with things there. And in addition, I'm going to be zooming into a deposition that day.
All day on September 1?
It's a corporate rep depot. So, but I don't know how long it's going to
Question
go.
is, how long is it going to last?
I don't have any control over it because it's not a deposition I'm taking.
Well, let me ask a better question. What time does it start?
I believe it's 9 o'clock.
And do you expect it to last past noon?
I would think so. I will say that the second is completely available for me, if that is available to everybody else.
It's not available for me, and that's why I didn't offer it up initially. I'm not available on the 2nd.
Is there any other date next week, Your Honor, that could work? I mean, if that's the only date it works for everybody else, I'll make whatever changes I need to, but it would not be ideal for me.
Well, what about Monday afternoon, the 31st? I'm assuming that day's good for everybody since that's when you were supposed to go to trial.
That works for me,
I'm
Your
not
Honor.
available. I'm not available in the morning, and frankly, I don't know what time I'm going to finish with that ish matter, but I could probably break free by 1:30 or 2 on that day. I could probably do the 31st at so only in the afternoon on the 31st, probably 1:30-ish.
Your Honor, can I stop the live stream?
Yes, you may.